Yes, please. Thank you. All right. Good morning, everyone. I'm going to give you all a minute to get logged in. I'm going to do the adoption first because that I think will go quickest.
There, you can just click.
I need to start.
What do you mean, sticky?
Yeah, because I need.
But before I do the adoption, Mr. Zand and Ms. Phoenix, have y'all had an opportunity to talk about your exhibits? Would it help for me to, while I'm doing these one or two uncontested matters, to put y'all in a room to talk about exhibits, or have y'all already had a chance to do that?
We haven't.
Judge, we have not spoken about exhibits yet.
Would you think that would help if I give y'all like 10 minutes or so to do that?
Yes, Your Honor.
Sure, Judge.
I will create a breakout room so that y'all can talk. If you get done and I'm not back in there, just join the main session. Or if you need any help, just hit that question mark or whatever, and I'll come in and join y'all. But I'm going to let y'all be working on that while I'm doing these other cases.
Judge,
Okay.
can you do the breakout room for my Zoom? I'm going to go back up to my office and
I will.
thank you, Your Honor.
We get the record set up for the termination adoption. Get going. Ms. Phoenix, I had you in a breakout room and I saw you just rejoined us, so you may have had some trouble. Do I need to place you back in there?
Judge, we haven't seen the breakout room pop up yet.
Oh, okay,
It's
let me
wait to
try
be
it
assigned.
again. And Mr. Rabinowitz, what is your role in the termination adoption?
Yes, sir. I represent the bio dad who's being terminated and has signed an affidavit of voluntary relinquishment. I'm just an observer. I'm not going to be taking an
understand.
active role.
Okay, thank you. I just was making sure I knew all the players.
Thank you, Judge.
The court's on the record in cause number 21, DCV 280826, in the interest of Reagan Conrad. Counsel, if you would, please each identify yourselves and the party that you represent for the record.
Good morning. This is Melissa Massoum. I represent the petitioners, Adam Flores and Alyssa Conrad Flores.
Corinna Steele, I was appointed to represent the child as the amicus.
All right, and Ms. Masum, what do we have this morning?
We have a termination, Your Honor, with a voluntary relinquishment on file. And then we have the adoption by the step parent.
Okay, we're going to go ahead and take care of the termination case first. And then Mr. and Ms. Flores, when we finish that, we will do the adoption immediately following that. So if each of you would please raise your right hand to be sworn. Do each of you solemnly swear or affirm the testimony that you're going to give in this call to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes.
All right, thank you. You may put your hands down. Ms. Masum, you may call your first witness.
Thank you, Your Honor. I'd like to call Mrs. Flores. Mrs. Flores, can you state your name for the record?
Alyssa Conrad Flores
And what is your relationship to Reagan Ramsey Conrad?
is my daughter,
And how old is Reagan?
12.
And who is Reagan's biological father?
Robert Seymour?
And were you and Mr. Seymour ever married?
No,
And has Mr. Seymour been a part of Reagan's life at all?
never.
And did you tell Mr. Seymour about Reagan and when you were pregnant?
Yes,
And has he ever paid child support or attempted to support you in any way financially?
no.
And when was the last time you actually saw Mr. Seymour?
Probably when I was 4 months pregnant in 2000 and what's 12 years ago? 2008.
And your understanding today is that Mr. Seymour actually signed a voluntary relinquishment with the court, correct?
Yes, I understand.
And at this time, Your Honor, I'd like the court to take judicial notice of the affidavit of relinquishment filed on April 1st, 2021.
Any objection, Ms. Still, to me taking judicial notice of that?
No, Judge.
The court will take judicial notice of that affidavit.
And Mrs. Flores, you're asking the court today to officially terminate Mr. Seymour's parental rights, correct?
Correct.
Okay. And do you believe that this will be in Reagan's best interest?
Absolutely.
I pass the witness, Your Honor.
Ms. Still, your witness.
Thank you, Judge. Is it fair to say that when you told the biological father that you were pregnant, that he was adamantly opposed to being a part of this child's life?
Absolutely. He was opposed 100%.
Okay. And from what I saw in the petition, the family, the grandparents, the extended family of the biological father were also not interested in having any role in your child's life.
Correct.
Okay. That's all I have, Judge. I'll pass.
All right, anything further, Ms. Masum?
No, Your Honor.
All right, Ms. Masum, you may call your next witness.
I'd like to call Adam Flores.
You may proceed.
Mr. Flores, can you state your name for the record?
Adam Flores III.
And Mr. Flores, you're here today to officially adopt Reagan, correct?
Correct.
And you are also aware that Mr. Seymour has signed a voluntary relinquishment, correct?
Correct.
And do you agree with everything your wife just testified to?
Yes.
And do you believe that this termination will be in Reagan's best interest?
Yes.
I pass the witness, Your Honor.
All right, Ms. Steele?
Yes, Judge, just briefly. Mr. Flores, have you had any contact at all with the biological father ever?
No.
And nobody on his behalf has contacted you to try to negotiate some type of visitation or anything else with this child? Okay, perfect. That's all I have. I'll pass.
All right, Ms. Masum, anything further from this witness?
Nothing further, and I have no other question, no other witnesses, Your Honor.
All right, the court finds by clear and convincing evidence that the alleged father, Robert Seymour, has executed an affidavit of waiver of interest that constitutes an unrevoked or irrevocable affidavit of the relinquishment of his parental rights. The court finds by clear and convincing evidence that the termination of the parent-child relationship between Robert Seymour and Reagan, the child the subject of the suit, would be in Reagan's best interest, and the court is hereby terminating that parent-child relationship. Additionally, the court finds that a paternity registry search was done in this case, and the court's going to take judicial notice of that paternity registry search that was returned, and that there is no father that has claimed any interest in this child under that paternity registry search. So therefore, the court is also terminating any parental rights that might exist between any unknown father and the child the subject of the suit. And with that, that completes the termination portion of the matter. So let's bring the star in. If Reagan's available, we can bring her in and we can do the adoption. Good morning, Reagan. How are you this morning?
Good.
If you can do me a favor and raise your right hand, I'm going to ask you to take an oath. Do you solemnly swear or affirm that any testimony that you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. Ms. Masumi, you may call your first witness.
This time I'd like to call Mr. Flores. Mr. Flores, can you state your name for the record, please?
Adam Flores III.
And what is your relationship to Reagan?
Her father now.
And how old is Reagan?
12.
And how long have you been in Reagan's life, Mr. Flores?
4 years.
And are you and Reagan's mom, Alyssa Conrad Flores, married?
Correct.
And when did y'all get married?
We got married in February of 2020.
And we're here today for you to adopt Reagan officially. Are you aware of all the rights and duties that come with this adoption?
Yes.
And are you ready to take that on, take that responsibility on today?
100%.
And do you believe that this adoption is in Reagan's best interest?
Yes.
And are you and Mrs. Flores asking for Reagan's name to be changed today?
Yes.
And what would y'all like the name to be?
Ooh. I guess we didn't talk about that. You want?
Well, we can come back to that. And
She said Reagan Ramsey Flores.
okay, Reagan Ramsey Flores. And are you and what has Reagan been calling you?
Dadum.
All right, and I have no further questions for Mr. Flores, Your Honor.
Thank you, Ms. Masoon. Ms. Steele, any questions of Mr. Flores?
Just briefly, Judge. Mr. Flores, we've talked before. Has anything changed in how you feel about Reagan during the past several months?
I probably love her more.
Okay. So what you're asking the judge to do today in signing the adoption is to formalize what you already feel for her. Is that correct?
Yes.
Okay. And so you understand that once the adoption order is signed, it'll be just as if you and your wife had her from the very moment of her birth.
Yes, ma'am.
Okay. And that's what you want.
Yes.
Okay. I'll pass the witness, Judge.
I have
Ms. Masoon,
nothing
anything?
I have
All right, Ms.
nothing
Masoon.
further, Your Honor.
You may call your next witness.
I'd like to call Alyssa Conrad Flores.
You may proceed.
Mrs. Flores, can you please state your name for the record?
Alyssa Conrad Flores.
And Mrs. Flores, you heard your husband's testimony just now. Do you agree with everything he just said?
Yes.
Do you believe that this adoption is in Reagan's best interest?
Yes.
I pass the witness, Your Honor.
Ms. Steele?
Yes, ma'am. Yes, sir. Ms. Flores, nothing's changed for you either as far as wanting your husband to adopt your child?
Correct. Nothing's changed.
Okay. And you understand as well that if something happens and your relationship does not last as far as your marriage is concerned, it would be just as if this child was born to him. He would have rights to visitation, duties to, there would be a duty to support. All of that would have to be determined
Understood.
by the court. Okay. And I'm not suggesting that's going to happen. I just want to make sure that everybody's on the same page, that this is a forever thing. Once she's adopted, she's his child as well.
Okay.
Okay, I'll pass.
Ms.
Nothing
Mas-
further, Your Honor.
Ms. Masum, any other witnesses you'd like to call?
I'd love to call Reagan.
All right.
Reagan, can you tell the court what your name is right now?
Reagan Ramsey Conrad.
And what would you like your name changed to be, Reagan?
Reagan Ramsey Flores.
And are you ready for Datum to be your dad officially?
Yes.
Nothing further, Your Honor. I pass the witness.
And Ms. Steele?
So Reagan, the day's finally here. Are you excited? Hello? Did she freeze?
No, go ahead.
Yes.
Okay. So nothing's changed since we spoke. You're happy that Adam's going to be your dad from now on?
Yeah.
Okay, that's all I have, Judge.
Ms. Masum?
That's all, Your Honor.
All right, Reagan and Mr. and Ms. Flores, the court has reviewed your paperwork. The lawyers have done an excellent job on the paperwork. Everything is in order. And I find that all the prerequisites for an adoption have been met. And Reagan, I've heard your request that your name be changed to Reagan Ramsey Flores. And I'm going to honor that request. So I'm going to sign an order here in just 1 second. And it's going to officially make Mr. Flores your dad now. And it's also going to officially change your name to Reagan Ramsey Flores. And I can tell you that for this court, it's always an honor to take part in these special adoption days. And it's a special, special day for you, Reagan. And it's a special day for the court as well that I get to take part in it. So congratulations to you all. And I've signed the order. You're going to want to get a copy of this order from the district clerk's office. And your lawyers already put provisions within the order for you to be able to do that. So the court signed the order approving the adoption. And with that, we're going off the record.
Thank you so much.
Thank you, Your
Y'all have a
Honor.
good day.
Thank you.
Thank
You too.
You're welcome. Which cases?
It's on the last page. On the last page, it's the divorce.
Oh, so Judge Heppard has that one. We might want to right now, unless she's sending it to me.
I think she's sending it to me.
Oh, she is.
That's what she told me.
Okay,
But
okay.
She just went to the ladies' room. She'll be back in a minute. She said that you're over here.
Okay, she's wanting to send her to the self-represented litigants program, I think. So let me give you that email address. We can give this to her. other lawyers are still talking about exhibits, so we've got some time. Hopefully I can take care of her real quick.
You want her back compensated or?
Yeah, that'd be fine. I'm gonna bring her up here in just as soon as I finish this docket call, docket entry. All right, ma'am, if you want to come on up, I've got a note I'm going to give you. From my bailiff will give you, and I'm just going to cover a couple things with you. If you can give her that, because I actually didn't expect anybody live today, so I don't have my mask on me. But if you can hand her that. And so a couple things, we reviewed your paperwork, and there's 3 steps to getting a divorce. The first step is you file a petition for divorce that basically just says, Judge, I want a divorce. And that's the first of 3 steps. You did that step perfectly. So that's all done. You don't need to redo anything there. The second step is your husband either gets served with papers that says, hey, sir, you've been sued by your wife. She's suing you for divorce. Or he signs something that says, I don't need to be served. I'm waiving that right or giving that right up. I know she's filed for divorce and I'm okay with that. So your waiver, you had him sign it, but the problem is the law says that waiver has to be signed after you've actually filed your petition. And your waiver was signed, or he signed the waiver like a month before you filed. So the way. Oh, so you're here as the respondent. Okay, well, that fixes the second problem. So you can actually cross through that second. Let me, on that waiver service, you can cross through that. You don't need that. But the third step is you actually have a final decree of divorce that's signed by both of y'all that says this, that is an order that I sign that officially divorces you. And it lays out any property that you have that you're keeping, any property that he has that he's keeping. And right now, we don't show that that decree has been filed yet. So have you got that form? Do you know? Okay, so it'll be an easy one. Because there's not going to be a whole lot to it. If he was here this morning, I could just send you down to because I would send you down the second floor because we have that form here. Really? And have you called him today? He's not answering? Because if he was here, I could get, well, I'll be here all day. I've got a trial I'm about to start and they announced 6 hours. So I'm going to be here all day in trial. So if you can get him here, it would literally take us probably 2 or 3 minutes for me to finish your case. But I've got to have him here since y'all don't have the decree yet. If he had signed the decree already, then okay. Sure. Well, The other option is if he can't get to court, but he lives close by or works close by, and you can actually go by to his place and have him sign it, you can do that also. And then you can come back, as long as he signs the decree and you say under oath, Judge, I recognize that's his signature. He signed that, then it doesn't have to be notarized. So you can take it to him, have him sign it, and then you come back and I can finish your case. Well, here, let me give you the form though. So you need to go to the second floor. And so is the child, all the children are out of high school? Okay, so the 19-year-old's out of school, out of high school. Okay. So if you go down to the second floor, there's a law library there, and just tell them you need a final decree of divorce with no children. And it'll be about 8 or 9 pages. And it's going to have a bunch of blanks to fill in for like who's getting what house, who's getting what cars. The houses, if there's not a house that y'all bought during marriage, then you can just put NA or put none. Yeah, don't leave it blank because then it looks like we forgot to fill it out. So just put none on that. But you do want to make sure even if it's titled in your name alone, or it's the car's titled in his name alone, if y'all have cars, go ahead and put that down, your year, make and model, that you're getting your car, he's getting his car, because that way there's no title issues later on. This official court order will say it's your separate property. He doesn't have any interest in your vehicle and vice versa. There's a little box to check if y'all have retirement. You can check you're keeping your retirement, he's keeping his. And then the standard form will say you're keeping your bank accounts and he's keeping his bank accounts. So it shouldn't take you very long to fill out, but you need to get that form on the second floor. And while you're down there, just tell them you need a BVS form also. So I think the second and third thing I put down there, you still are going to need those, but make sure you tell them no children, because if they give you the one with children, it'll have like 35 pages of stuff you don't need. Okay. And then just come on back up. What you can do is those doors will be unlocked as long as I'm in trial. And even if you come back and they're locked, like if you come back at 12:30, I may be at lunch, and the bailiff and the clerk will be at lunch, but I'm still here. Like I don't leave the facility. So just go, there's a little cubby hole right there. You can hit the 387th button and that'll ring back to our office, and I'll come out and take care of your case whenever you get back out here. If you get back out here and I'm in trial, which is probably more likely, it's going to be a Zoom trial. What'll happen is just have a seat. My bailiff will let me know you're here because I'll be focusing probably on the monitor. But when I see you, as soon as I get to a point where I can break them and tell them I just need a 5-minute break, I'll break that case and I'll take care of your case. Okay. All right. Thank you. I'm going to go jump in this room and check on the lawyers. All right, the lawyers are still working on exhibits, and they're making a lot of progress. They've asked that I start the trial at 10:30, so I will take a break until 10:30. We'll come back and get started with the trial. We're going to break and be in recess until then. Mr. Ray and Mr. Anderson. Just to give
Morning,
you all a
Judge.
heads up. I'm about to start a 6-hour trial. And so I told them I'm starting them at 10:30 because they're still working through some exhibits. So I went to take a break and they told me that y'all were been sent over. So let's kind of talk just briefly about what we have set this morning and what the matters are. Because I know y'all are set for final trial in January. And I think y'all have a status conference in December.
Your
So,
Honor,
Mr. Anderson, I know it's your motion, but kind of if you'll tell me what you'd like to see the court address today, if anything, and then I'll let Mr. Rea respond, and then we'll see what, if anything, I can hear.
the trial that was set in January, I just wanted to clarify a couple of things. The trial that was set in January, I notified the court coordinator that I had a conflict. I already have a trial scheduled here in Missouri. So she told me that she would go ahead and cancel that. I believe that that's been done.
And Judge, we filed an order for protection that protected both myself and Mr. Anderson that I believe you or Judge Heppard formally signed that
Yeah.
should be sufficient to protect Mr. Anderson from any other settings.
I
Or
don't
otherwise,
have the other setting.
I do know I signed, or I don't know if it was me, but I know when I was reviewing this case, there's an order of protection that was signed because I knew that that was potentially an issue for y'all. And so we did sign the order of protection. So if the order of protection protects you from the January trial setting and the other trial was set after the order of protection or after this order was set, I don't see that we're going to have any issues there.
The other trial was set a year ago, Your Honor.
Then why would we set this trial on that day and do an order of protection for that day?
I didn't set this trial. I notified petitioner's counsel that I had the conflict immediately. They told me that the date was set by the court. I notified the court, told them I had a conflict because I already had another trial scheduled in Missouri. Janie told me that she would cancel the order. So
All I understood, Judge, was that there was a conflict. I wasn't aware of exactly what that conflict was. And I know Mr. Anderson is representing in two states. So I wasn't sure what sort of conflict that was, as I'm only aware and familiar with the priority and hierarchy of settings here in Texas, that if it would have been any sort of other setting or hearing or status conference, I would hope that a Texas order for protection on trial would be sufficient. Now, again, as you stated, if this was a trial set long ago, I guess at some point the two courts would not necessarily, but potentially have to discuss who gets to take on a matter. But it sounds like just from some basic discussion that today's setting ruling may help us kind of navigate through some things. So that may be premature of us fighting about that setting.
Okay. Well, I
furthermore,
mean,
Your Honor, we
Yeah.
still haven't gotten most of our discovery. So
okay. Well, so as far as the trial setting goes, I don't know that I really need to get too involved in this. From my standpoint, though, I'd never really like to have a temporary orders hearing or motion for additional temporary orders if I've got a trial 60 days down the road, because normally I just want to put a Band-Aid on something and get us to the trial setting so that we're not hearing it multiple times and lawyers having to try the case multiple times and parties paying for that. So that was kind of my thought, and that's why I mentioned the January setting. But if we've got an issue with the January setting, it may be something that we can remedy today and get a new setting and that works for both of you. So, and then I can do an order of protection for that new setting. But I can tell you if it's a setting that I get from both lawyers and I do an order of protection, then we're going to go to trial on that day. So I understand if it was set without your input, Mr. Anderson, and there might be something that was set previously that the order of protection is not really going to necessarily remedy that issue.
yeah, on the other matter, we were supposed to go to trial in March of this year, but because of COVID, we got pushed to January of next year.
So we're going to come back to that in a little bit, but let's deal with what we got today. And we don't have a motion for discovery on the plate today, so I'm not really going to get into discovery issues unless that's preventing y'all from having a hearing today. and then we can discuss getting some kind of supplemental deadline so that y'all can get your hearing date set. But what is it that you think needs to be heard today, Mr. Anderson?
Your Honor, I think, given discussions with Mr. Rea and my client, I believe that the only thing we need to have a very brief hearing on today is Christmas visitation, or Thanksgiving and Christmas visitation. My client cannot do visitation on Thanksgiving. She was denied her visitation in August because she couldn't pick up the children on the specified date due to training issues with her new job.
Judge, I'll object as to facts not in relevance, but appreciate that you can filter through some of this stuff.
Yeah, I'm taking it as argument to counsel, but I
Okay.
appreciate it.
Thank you,
Go
Judge.
ahead.
And at this point, we're just dealing with the question of visitation for Christmas.
Okay.
So, Judge, temporary orders from back in April addressed Christmas per a standard possession order. You'll see that on page page 7 and 8 of the temporary orders. Judge, you may have actually signed, but it could have been Judge Shepard. Yes, it was Judge Shepard. No, I believe it was you. I can't always read signatures.
Heard most everything, but if it's an agreed order that comes in, then, you know, either judge may sign that, but
It looks like your signature, Judge, on May 14th. But it addresses the division of the days. The only issue that we specifically reserve on page 8 in paragraph 8 was the travel for exchanges. So I believe per this order, Mr. Anderson is requesting that Mr. Kaloff do all of the driving. And if you remember, this is a case that is in Fort Bend County, but Ms. Rawas has now resided in Missouri for this past year. And it's our position that based upon some of the inability to follow through with some of the or not even follow through, but exercise the rights to possession, that along with no support being paid, that Ms. Rawas be the traveler to and from her residence.
okay. So, Mr. Anderson, looking at page 7 of the temporary orders that I signed, it says for Christmas in odd numbered years that just one second. That Mr. Koloff would have the first part of the Christmas break, which would be when school lets out until December 28th at noon. And then your client would have beginning December 28th at noon until 6 p.m. the day before the child or children resume from the school vacation. So so it looks like the court's already dealt with this. Are you telling me that that's unworkable for some reason, or what is the?
Well,
are you just
Your
worried
Honor, my client was also supposed to have visitation in August.
I'll object, as that is something that's not before the court today. If referenced that we are talking only about Christmas.
Sustained. And so here's the thing, Mr. Anderson, this court's ordering the visitation. And if your client complies with the order and doesn't get the child, I will address that with Mr. Koloff. And, but it's not before me today. So there's a remedy that's there if someone violates a court order, but that's not what I'm dealing with today. I'm going to work under the assumption that if we have a Christmas break that's dealt with in a temporary order, that both sides are going to obey that court order, and they're going to, your client's going to get her visitation. So assuming, hold on just one second, Mr. Ray, Mr. Anderson, assuming that this visitation is complied with. Do you have any issues with the visitation days? Or are you just telling me that you're worried you're not going to get it? Your client's going to get it?
Well, Your Honor, there have been 2 prior visitations that were missed. Now, counsel's going to object and say that this is not before the court. There are 2 prior visitations that have not been met. My client hasn't seen the children since June. Okay. It's now November. All right. She missed 2 weeks in August because she could not pick up the children as specified due to a job change. Okay. We attempted to remedy that. And this initial filing was an attempt for an emergency hearing to try to address that. Due to scheduling, due to judicial conference, due to family law conference, due to a lot of other things, we kept getting pushed back. So now it's November. Okay. My client hasn't seen the children since August, or pardon me, since June. We're requesting that she be given the entire Christmas break. Okay.
All right, well, I'm not gonna modify this temporary order without having a hearing where like if there was an enforcement filed saying that Mr. Coliff had violated the court order, and I found that he had violated the court order, then more than likely what I would do is I'd be giving her makeup time for the visitation that she missed. And that might include Christmas, that might include more time in the summer, but I would definitely give her makeup time if I found that he had violated a court order. But I haven't made that finding, and that's not before me today. So I'm not going to modify this temporary order and give somebody more time when I haven't even had him give his side of the story on what happened. Because it could be that she failed to comply with the court order, and that's why he didn't give her the access and possession time. But I don't need to decide that fight today because it's not before me. So I don't want to focus on the 2 visitations that she didn't get. If that in fact happened and he violated a court order, get those pleadings in front of me and I'll address them at that time. But I'm not going to address them today because they're not in front of me. And I'm not going to modify this temporary order where we have dates allotted for mom and for dad to have during the Christmas holiday. So she's going to get her visitation and she's going to get December the 28th at noon until the day before at 6 p.m. when school resumes. From my standpoint, if there's any issue that we need to resolve today, it's going to be the pickup and drop off. And my view is, since we've had issues with pickup and drop off in the past, that mom needs to pick up the child here for sure. There's no doubt about that. That's what's going to happen. My only issue is previously I have had dad go pick up the children at mom's residence in Missouri or somewhere around there. And I might do that. I'm not sure. That's something I would want to take argument on, but definitely mom would be picking up here because if mom doesn't exercise her visitation, I don't want dad driving 3 states away to go drop off the children and then something go wrong and she not be able to take the children. That just doesn't make sense to me.
Judge,
There was
I
no
believe
issue
the
with her
argument
being able
regarding-
to have it.
Hold on, one at a time. Let's go Mr. Anderson first and then Mr. Ray, I'll give you an opportunity to respond.
There was no issue with her having the children at that time. The issue was her getting off of work so that she could make the 12-hour drive to get the children and get back in time for work.
I understand.
That's been the only issue is because of the distance and her ability. Like I said, she had a new job at the time because the Amazon job she had previously refused to allow her any time to go and get the children.
Well, and she can designate somebody to get the children. So her parents, I know they've done it previously. They just need to make sure they've got a car seat, and safety seat. But the parents can come. She can designate anybody to do the pickup and drop off that's familiar with the children. It doesn't have to be her because I want her to get her time. But that being said, I also am not necessarily going to make dad drive to Missouri, especially both legs of the trip. That's not going to happen. Mom's going to need to pick up here for sure. And then I just need to deal with how we're getting the children back. And I'm not 100% sure how I want to do that yet. But that's what the court's ruling is going to be. I can tell you that. We're going to keep the possession that's in the temporary orders. And if there's issues, Mr. Anderson, with past missed violations, you just have to get that in front of me and I'll address it at that time if I need to. All right, so do we want to take arguments over how we transport the children? I guess, Mr. Anderson, what is your position on it? And well, I didn't give Mr. Ray an opportunity to respond to the prior stuff. So Mr. Ray, is there anything you wanted to add before we get into exchanges?
No, nothing further, Judge. My responses can go directly to distribution of driving or travel.
So, Mr. Anderson, I get it that she's got a new job and I totally get that situation. But I also think that she's going to have to designate somebody if she can't get down here. So that it's at the time that she's supposed to pick them up. Because if she shows up December 29th at noon and the court order says December 28th at noon, you can come in and say, well, Judge, we got there on the 29th at noon and he refused to let us have the children. And he said that we were late. And so we want our time. And I can't hold him in contempt for that. She's got to meet the prerequisites of what the court order says in order for me to be able to hold somebody in contempt. So she needs to make sure that if she can't be there December the 28th at noon, that she gets somebody that can be there December the 28th at noon. Now, Mr. Koloff, if they get there at 12:30, that's kind of my cutoff point. Normally it's 15 minutes if the parties live close to each other, 15 to 30 minutes. But if they get there within 30 minutes of noon on the 28th, let them have the children. If they text you ahead of time, it says, hey, we just landed and traffic's terrible. We're actually going to be like an hour and a half late, but they're texting you in advance of noon on the 28th, let them have the children. It's just common sense and not something that I really feel like as a judge, I need to lecture too much because I assume the parties are going to behave themselves. But I just want you to hear that because Mr. Anderson, if she does show up on the 29th, technically you can't just show up anytime you want and get the children under Texas law. You got to show up at the time that you're actually supposed to get the children. And so I want to make sure that's clear to both sides so that both sides make whatever arrangements they need to make in order to actually have this visitation take place. Because if she hadn't seen the kids in 5 months, that's terrible. She needs to see the kids, but she's got to do whatever she needs to do to make sure she does.
Your Honor, she attempted to do that previously. She told them she couldn't pick up the kids on that day. She asked if she could pick the kids up on a later date. She was refused.
Well, and then that's, so if it's a later day, that she's kind of at his mercy there, right? I mean, the court order gives you specific dates. And ideally, in these cases, the parties could work with each other and co-parent and make switches and accommodate one another. But in probably 7 out of the 10 cases that come in front of me, there's not an ability to do that right away. And hopefully we get to that point at some point in this case. But right now, she just needs to assume that he's going to say, you got to follow the letter of the law. And Mr. Koloff, I'm not saying you did that. Your lawyer may say that there were other reasons. And again, I don't want to get too much into this because it's not in front of me. But what I'm saying is you need to assume, both sides need to assume that the other side is not going to give them accommodations right now. We may not be in a place where we can really do that yet. And so everybody needs to just follow the court order. And then hopefully at some point down the road, we can begin to become more flexible with one another and accommodate one another's schedules. But I can't force that on anybody. So if she shows up 2 days late and says, I want my Christmas visitation, as a judge, I can't do anything to Mr. Koloff. Now I can give makeup days, and a lot of times I will do that. But that really depends on the facts of the case. All right. So Mr. Anderson, is she going to be able to be here December the 28th at noon? Do you know?
Will you be able to be there? Yes, Your Honor, she will be there.
Okay. Well, that's good because I want her to see the children and I want her to have that visitation time. Now we need to deal with how to get the children back. My thought is.
Can I respond, Judge, before
Yes,
you proceed? Judge, if you'll recognize that Ms. Rawas does not pay any support to Mr. Koloff, and under the statements by Mr. Anderson, without really any time where the children were in her care where she provided anything financially for them. Furthermore, you'll remember that she moved last December under kind of false pretenses of abuse.
Your
And
Honor, I object to that.
well, it's a
Hold on,
direct.
hold on.
I object to that.
It's just argument. I understand you don't you disagree, but it's just argument at council. Nobody's under oath. I'm not taking evidence. I'm just listening to argument at council. So overruled. You may continue, Mr. Ray.
Mr. Khalaf has incurred more than $30,000 in fees. And in addition to the Missouri protective order case that was dismissed, there are no assets in this matter of the community that the court can divide disproportionately to compensate Mr. Khalaf for all these expenses that he's incurred. And by statement from Ms. Rawas to Mr. Khalaf, she's not paying Mr. Anderson any money. So this disproportionate expense is very difficult because the court will have no way to offset the expense incurred by Mr. Khalaf to address reasonable things. And that's responding to every motion that must be, that has been filed for the court, whether we presented it, had a hearing or not. Specifically, Judge, this may be the only financial and time and effort way that the court has some control to compensate Mr. Khalaf for the financial burden that he's bearing in this court proceeding and in the Missouri protective order proceeding. And that seems to be the only reasonable way for this Christmas. We're speaking specifically about this Christmas, and I believe, Judge, you'll carry no weight from this Christmas on to these future division of exchange responsibilities. But this Christmas, considering what's going on procedurally in this matter and how much burden that Mr. Khalaf has borne, it seems only reasonable that Ms. Rawas be the responsible one for the picking up and returning, specifically since the children will need to be in with Christmas ends at 6 p.m. on the day before school starts. And with the court not modifying that exchange time, it seems exceptionally unreasonable and unworkable to say Mr. Khalaf will be in Missouri at 6 p.m. and somehow get these kiddos back to Texas for a school day that starts, let's just say, at 8. So it seems there's nearly an impossibility for Mr. Khalaf to travel to Missouri, pick the children up at 6 o'clock, really any place but the marital residence, pick them up at 6 o'clock and have them ready for a school day, especially since the court's already decided that we're not modifying a previously agreed upon time of possession for Ms. Rawas.
Now, just so I'm clear, though, it is a 4 and a 3-year-old, right?
5 and 3, Judge, now.
5 and 3. Okay, so is the 5-year-old enrolled in kindergarten?
Kindergarten?
Yes.
Or is it just, okay. All right, Mr. Anderson, response?
Yes, Your Honor. With respect to the financial situation. So there's a statement that she's not paying me. This is untrue. She pays me just like any other client does. Second, no marital assets. This goes back to the discovery violations that we mentioned in our motion.
Referencing things not before the court.
Overruled. You may continue, Mr. Anderson.
We provided the petitioner with the tax assessor's records that show that Mr. Khalaf bought the marital residence during the course of the marriage. Okay? We requested copies of the deed, copies of the purchase, Those have not been provided. The marital residence was then transferred from Mr. Khalaf's name to Mr. Khalaf and his son's name.
Judge, assuming facts not in evidence.
Let's stick to just the pick up and drop. But we're going to have a day where we have that fight, Mr. Anderson. But
Yes, Your
I
Honor.
don't have, I'm starting a trial in 4 minutes, so I don't have time.
No, I understand. So the marital assets are not in question. My client has already purchased plane tickets for the children previously. She's already done things to which were then lost because he refused to turn the children over to the aunt and uncle.
Judge referencing
Incurred expenses.
already
Also-
presented to you previously.
Yeah,
Also-
I recall that, So let's focus on just the cost associated with it, moving forward and the issue with the school, Mr. Anderson.
Now, we have requested that he transport the children on the 28th. He deliver the children to her in Missouri on the 28th. She would bring the children back and deliver the children to him at the marital residence on the day before school starts. That way, the transportation issue and all of that is taken care of. One drives one way, one drives the other. She's here in Missouri, not because she chose to move to Missouri. She moved to Missouri because that's the only family she had to go to. And in order for her to leave the marriage, she felt she needed to get out of the home. Okay, so the only place she had to go with no money and with no assets was to her aunt and uncle's home in Missouri. Previously, where there were issues of domestic violence in the marriage, this is the place that she came because this is the only place she had to go.
Relevance.
So she's here. The distance involved is here because she has nowhere else to go.
All right, and what, Mr. Anderson, I know she got a job last time, or previously in one of the hearings. I don't know that I've heard a whole lot of evidence on it, but what is she doing now? Is she a substitute teacher or what is it?
Previously, she was working at Amazon. Amazon refused to make any accommodations for her to visit with the children. So she had to leave Amazon. Now she's an administrative assistant at a trucking company.
Okay.
I don't believe we've been noticed of that change, Judge.
Now, she just finished the training. I mean, before you were doing training for how long?
I wasn't even paid for the training.
No, before she was in training, now she started the job. She says she's been there now on the payroll for a little over a week and a half.
Okay. Well, make sure on both sides, if there's significant changes in like employment, someone loses a job or gets a new job, you got a duty to notify the other side and make sure both sides are doing that. Oh, man. All right, Mr. Rhea, does your client have any issues with, and I know he doesn't want to, but does he have any issues with his job being able to deliver the children on the 28th if the court decides to do that and have her return the children?
Yes. I think it stems a lot from he doesn't want to. It doesn't feel that it's reasonable or fair under the circumstances and the history of these proceedings. And he has family coming in from the UK, the children's cousins, and we would clearly request and prefer that they spend as much potential time with them as possible, as they haven't spent time together as they would like. But that clearly, I mean, if we get to talk about all these touchy-feely things about why she moved and all this stuff, I think
That's
that,
okay.
I'm responding to the laughter from counsel.
Yeah.
My laughter was because the mother hasn't seen the children in more than 5 months. So
No, I understand that, but there's
But she
also.
has the right to,
Hold
Judge.
on. Oh, that's it. That's it. I've heard enough. There's a court order that gives visitation. And that's all I can do as a judge. If that court order is not followed, then the lawyers know what to file to get it in front of me. And that's not in front of me. So I'm not going to make rulings based on what didn't happen in the past that wasn't addressed by the court. Because if it happened and I address it, I'm going to fix it. Or I'm going to get someone's attention. I mean, it's just the way a court works. I expect my orders to be followed by both sides. And Mr. Colliff, I'm not saying you didn't obey a court order. I'm not letting your lawyer get into that today because it's not before me. But I'm just letting Mr. Anderson know that if there's an issue like that and it gets in front of me, I'll address it, but I'm not going to address it when it's not in front of me. And I'm not going to let that factor into my decision because it was never brought up to me. Look, here's the thing. I haven't heard all this evidence yet because neither side has had their opportunity to actually present their cases in chief. So I understand that there was a protective order filed in Missouri and that was dismissed. And that's all I have right now because I haven't heard evidence of the alleged family violence. And it could be that ultimately makes this court factor into some of the decisions that I'm making, but all I have in front of me right now is that the protective order was dismissed. And so based on that, and based on the fact that mom's moved away, this mother is going to be doing the pickup and drop off. That's for this Christmas only. So if going forward, this court may alter that, but I have not had an opportunity to have a full-blown hearing on family violence issues. If I find that someone legitimately left the state because of family violence and that was where they had to go to get to their safe place, then I'm not going to be making that person do both legs of the trip. And I may factor in the cost and take that away from child support or something along those lines. But if that's in fact proven to the court that there's been a history of family violence, and I'm not saying there has, I'm just letting y'all know I will alter this in the future if I find that. If I don't find there's any family violence, then more than likely the person that's moved away is going to be freighting the entire cost and inconvenience of doing pickup and drop off. So some of that's going to factor into what happens in a future hearing. But for purposes of this Christmas break, since I haven't had an opportunity to hear that, we're going to kick that can down the road until the final trial. And mom is going to do the pickup and drop off for this Christmas holiday. All right, if y'all want to get me an order, Mr. Ray, to that effect, you can. That's just for this Christmas. So anything beyond that, hopefully we will have a trial at some point and the court can be more intelligent as to what needs to happen there on a long-term basis. But entry of this order will be December the 3rd is a DWAP docket. So let's stay away from that. Entry of the order will be December the 10th. Mr. Ray, you'll draft, and it'll just be that short provision that pickup and drop off is to be done at father's residence by mother. All right, that completes the ruling of the court. Thank you, gentlemen, and
Thank you.
I'll have a good day.
Thank you, Judge. May I be excused?
You may.
Thank you.
Okay, Ms. Phoenix and Mr. Zan. What's hot? Is it hot in here to y'all? Huh? Oh, of course, Jeanette's cold over there. It feels kind of warm. All right, we're just waiting on Ms. Phoenix. I'm going to go ahead and get the record set up for y'all, and then we'll get started.
Thank you, Judge.
Judge, I didn't hear what you said. I'm sorry. My speaker was down.
I'm getting the record set up for y'all. It's just going to take me a minute, and then we'll get started.
Okay, thank you. I want Mr. I don't want Mr. to sit with me.
You don't want
I
him to
don't
sit.
want to sit with you. This is our camera. And I don't think it's comfortable sitting there. So I want him to sit somewhere where he can look at the trial.
Ms. Phoenix, you're not muted, just so you know.
Until I need it, I guess.
Until you need it.
Next, Ms. Phoenix.
Mm-hmm.
Good call.
Let's see. Am I on mute? Yeah. Judge, I'm sorry, did you say something to me?
I was just saying we can hear you, so I just wanted you to know you might want to mute if you're, I'm not sure, I'm not hearing what you're saying because I'm making a docket entry, but just wanted to make you aware that you're not muted.
Okay, I'll mute myself. Thank you.
Okay.
Wait a minute, I'm still moving this thing. Still not moving. Here it goes.
And Mr. Zan, can you do me a favor and get on the 387's website during our lunch break and circulate that waiver of appeal so that we have that by start of the afternoon break? Just send that to Miss Phoenix and y'all sign off on that so that I've got that.
I'll have my office work on it right now, Judge.
I'll put it on the record, but just rather have that also filed just so we've got it. Okay. All right, Ms. Phoenix, I'm ready when you are.
Is there?
Oh, we've got some serious echoing.
Ms. Phoenix, if you can talk, I think you may have some echoing going on. I just want to make sure we work that out.
Hello, test.
That's not too bad. There's a little bit, but it's.
You want me to, what can I do, Judge? You want me to put the other speaker on mute?
Is that your
Okay.
client in the same room as you?
Yeah, and he's in the next room. That's what the feedback is.
Yes, he's in another room, Judge.
Okay. I think I can work through it. If it becomes an issue.
We'll turn it, we'll see what we can do to turn it down.
It's not bothering me right now. So I thought when you first started talking, it might be an issue, but it seems like it's okay.
Yeah, how is it now? It doesn't sound, I don't hear anything.
Sounds good now.
Okay.
Okay, we're gonna get on the record. The court's on the record in cause number 20 CV 271334 in the matter of the marriage of Lynn Hodges and Gary Hodges. Counsel, if you would please each identify yourself and the party that you represent for the record.
Good morning, Your Honor. Dean Zane. I represent the petitioner, Lynn Hodges.
Joyce Phoenix representing the respondent, Gary Franklin Hodges.
All right, and Mr. and Miss Hodges, if y'all can get your videos up and running so I can swear you in, and then if you'll unmute for me.
Let me make sure my client can do that, Judge.
Lynn, can you click on on the stop video button to unclick it? I might have to go down there.
We're gonna go off the record while we work through Zoom issues.
Start video in the corner.
Now it says it cannot start video.
Here it is.
I've tried like 3 times now.
This is Mr. Hodges, Judge.
Morning, Mr. Hodges.
Good morning, sir.
Ms. Hodges may have to sign out and sign back in if the video is not working. I'm not sure if they can work through that, or maybe logging off and logging back in may work.
I know it's coming. It's coming, Ken. I wouldn't expect that.
There we go.
Okay, thank you.
All right, good morning, Ms. Hodges. We're gonna wait for your lawyer to get back to his room. and
Okay, thank you.
Ms. Phoenix to get back to hers, and then we'll get on the record.
All right, great.
I think, Ms. Phoenix, you're faster than Mr. Zan. The court's back on the record in cause number 20 DCV 271334. Mr. and Ms. Hodges, if you would please raise your right hand to be sworn. Do each of you solemnly swear or affirm the testimony that you're going to give in this cause be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I thank you. You may put your hand down. Lawyers, do we have any stipulations that we want to put on the record before we get started as far as the admissibility of exhibits? And let's start with Mrs. Hodges' exhibits, and she's the petitioner. Ms. Phoenix, do you have any stipulations to petitioner's exhibits?
Yes, Judge. We have agreed to petitioner's exhibits 1 through 24. 26 through 29, 30 through 41.
Okay, Mr. Zan, are you offering those exhibits at this time? Mr. Zan, you're muted, but are you offering those exhibits at this time?
I'm sorry, Judge. Yes, Your Honor.
Okay, so pursuant to that stipulation, petitioners 1 through 24 are admitted. Petitioners 26 through 41 are admitted. So that means petitioners 42 and petitioners 25 are not admitted, just so y'all have your notes are correct. Okay, now let's move to Mr. Hodges' exhibits. Mr. Zan, any of Mr. Hodges' exhibits that you can stipulate to?
Yes, Your Honor. We are stipulating to R1 through R51, Judge. We are not stipulating to R52. We are stipulating to R53, 54, and 55. We are not stipulating to R56. We are stipulating to R57 and 58. We are not stipulating to R59. And we are stipulating to R60 to R65.
Okay, and Ms. Phoenix, are you offering those exhibits at this time?
Yes, I am, Judge.
All right, respondents 1 through 51 are admitted. And respondents 53 through 55 are admitted. Respondents 57 and 58 are admitted. And respondents 60 through 65 are admitted. So what that leaves is respondents 52 is not in, respondents 56 is not in, respondents 59 is not in. All right, with that, why don't we, any other
Judge,
stipulations?
and Judge, I just need to clear up some of our stipulations on the exhibits, Judge. On the
Okay,
bank records that we've stipulated to, Your Honor, we are not so here's the issue, Judge. There were notations put on these records. And I don't stipulate to the notations on the records. I'm stipulating that the bank records are my client's bank records for purposes of efficiency and the fact that we've provided those documents in discovery. However, Ms. Phoenix's office made additional marks on the documents, and we want clear on the record that we are not stipulating to their notations on those bank records, so the court can be aware of that.
I understand. Ms. Phoenix, you understand that as well? They're not stipulating to the truth or veracity of the notations that were put on the bank records, just to the fact that the bank records are authentic bank records of Ms. Hodges.
I understand, Judge.
All right, the court will accept those exhibits, and those are in evidence with that one caveat. All right, at this time, any other stipulations or any matters that we need to take up before we start with our testimony?
Judge, we have a preliminary issue. We've issued a subpoena, which is on file, a return of service for Natasha Coe, Judge. She is not present this morning. We have attempted to contact her and have been unavailable, Judge. I don't know if she's possibly in Judge Hepburn's Zoom, but she's not here today, Judge. So that's something I will need to address prior to the commencement of this proceeding, because I anticipated calling her first to get her in and out as quick as possible.
And what is her relationship to the case?
She is a witness designated in R194, and she is an employee of Mr. Hodges.
Okay. And Ms.
She's
Phoenix,
his office manager.
Ms. Phoenix, do you know where Ms. Natasha is?
Possibly.
I'm going to go check Judge Hepburn's courtroom real quick, but I mean, just so we all understand, this court's going to issue, if there's a return on file and there's sufficient evidence that the witness fee was paid. I haven't looked at that yet, but assuming that those I's are dotted, then there's going to be a capias issued, and we're going to go pick her up. And I don't want to do that if we can get her into this Zoom call. So let's take a 2-minute break and make some calls and see if we can't get her in here so we can get her testimony done quickly. If not, then I'll address that issue in just a few minutes. I'm going to look at the return while y'all try to get a hold of her.
Thank you, Judge.
How do I?
All right, Ms. Phoenix, give me an update if you can.
Judge, the young lady was served last week. She has a surgical appointment today. Apparently, she has what they believe to be a cancerous growth inside of her nose. And they are either going to start radiation or they're going to do surgery to take it out. And she had to go today because they're making that decision. She said that she called and left a message. I don't know if she called Mr. Zand or who she called, but she talked to somebody and let them know that she was not going to be able to make it today. She had the appointment prior to being served. So she was served on Friday. She already had this appointment, and this is a serious situation with her because she had open heart surgery previously, like 2 or 3 months ago. So something's growing inside of her skull, and they're trying to figure out which way they're going to go. So she had to make her appointment today.
All right, I'm going to put the lawyers in a breakout room and we're going to chat for a second.
Okay.
Ms. Phoenix, I have you down twice and both of them are Joyce Phoenix. So hopefully I'm moving the right one.
This is me right here.
Yeah, I know, but they're both, let me rename this.
One of them is, I think the other one is my paralegal. We're all online in here, just trying to get it done.
I got you. All right, that'll help me now.
Okay, I see it.
You guys asked for part two, so here it is. My mom asked it to my house, my kids, address was us. This is the man, the myth, the legend, my dad, reporting insecure. You guys asked for part two, so here it is. My mom asked it to my house, my kids, address was us. This is the man. We want to come out and play it for dinner. Okay. I didn't know that it was so controversial, especially on Instagram. So to share a little bit about our contract with you guys and what it entails. If you're thinking about your professional career wedding, this is a fun way for you guys having us. For the guys, when both of the parents took their seats so they could watch the processional, and the officiant took his place at the altar. Actually landed over professional. What I love about this is they walked to the corner of standing next to the groom, meaning the best man walked right behind the groom instead of coming last and taking his spot. This is a fabulous way to give the guys their dessert. If you're thinking about it's time to turn our house to the North Pole, and I'm starting just at our front door. I'm using this buffalo plaid wrapping for us, just like a present. And I just take it on, take, and I make sure to get the top. And then for the
This is the last time I'll address it. It's a working dog, not a pet dog. It's not at a pet dog weight. Any vet chart that
Why is there a little buddy?
hello from the UK.
Okay, the court is back on the record in the Hodges matter. Mr. and Ms. Hodges, if y'all can get your videos up and running again, we're about to get started. We broke briefly off the record to deal with a witness issue. And we have Natasha Coe, and I'm not going to go into the details since we're live streaming, but she's got some issues and is currently, we believe, at a medical facility. And the court's going to hold off on issuing any kind of orders to have her picked up. And I'm going to wait until 1:30. We're going to give her some time to check in with the court and see if in fact we get some kind of response from her today. So we're going to go ahead and proceed, Mr. Zand, without Ms. Coe at this point. But the court's going to address this issue at some point before we finish. And we'll deal with that, making sure we get this witness in before we close the testimony on the case. All right, with that being said, both witnesses were sworn in. I'm going to let each side give a brief opening. Mr. Zand, you represent the petitioner, so you may go first. If you'd like to give an opening to the court, you may proceed.
Thank you, Judge. Your Honor, this is a divorce involving a marriage since 2011. There are no children involved, which I believe will simplify some of the issues, not to mention, Judge, there are significant arguments on behalf of Ms. Hodges in which the respondent, Mr. Hodges, since the filing of this divorce, Judge, has violated the injunctions that this court put in place and has caused the community to incur basically unnecessary expenditures. Judge, we have pled fraud on the community as well as waste of community assets, Judge. And a majority of the focus today, Your Honor, is going to be on a reimbursement claim to reconstitute the waste committed by Mr. Hodges, what we believe to be waste, Judge, committed by Mr. Hodges throughout. And I'm focusing, Judge, on the time from divorce onward. I'm not going to be going back to a time period when these parties were married, living under one roof, cohabitating, Judge. I want to focus on moving forward after the divorce was filed and what's happened since then, Judge. And so I'm limiting my focus of this case to that time frame, primarily for the reimbursement claim, Judge. And I think the evidence is going to show you that there have been significant cash withdrawals, expenditures, purchases, checks written that I don't believe Mr. Hodges can address and answer with where the funds went or what were they were used for, Judge. And so I believe once the court hears the evidence presented and sees it for its own eyes through bank statements, Judge, the court will deem that there is a reimbursement claim owed to this community estate, Judge. And the concern is with that, how will the court address that? Whether that be in the form of a judgment, which we're hoping it's not, Judge. My client is asking for spousal support. This marriage is over 10 years. And we're asking for spousal support so that there are teeth in this court's orders, which would then hold Mr. Hodges accountable for reimbursing Ms. Hodges for these waste of funds and community and fraud on the community, Judge. And so I believe once the evidence is presented, you'll see why Ms. Hodges is asking for the relief she's asking for, which is significant reimbursement, Judge. There's a residence that Ms. Hodges owned prior to marriage. There's no dispute, I believe, regarding that separate property estate, Judge. That is her home. She purchased it before the marriage. There was no loan on the property. It was paid in full. I believe Mr. Hodges is going to be arguing that mud taxes and other expenses paid for the residence should be reimbursed, Judge, which we're going to argue against. There were some small improvements such as irrigation and AC repairs, which were done on the residence, Judge, but the evidence is going to show you that those monies were taken from Ms. Hodges' mother. Her mother provided her approximately $50,000, and she used those funds to improve the home, making repairs which were necessary, Judge. We do not believe that there are any additional reimbursement claims on behalf of Mr. Hodges, Judge. The parties have a dog named Justice, which is what the business AAA Justice is named after. That pet was purchased by Mr. Hodges as a gift to Ms. Hodges, and that's undisputed. I believe that's stipulated in both parties' inventories, Judge. However, Mr. Hodges, you'll see through his request, Judge is asking for reimbursement for any penny spent on this dog. And I think that's absurd, Judge. If it's a gift made by Mr. Hodges and he agreed that the party should have this dog because he purchased the dog, I don't see how that's warranted that a reimbursement claim should be made in regards to expenditures that he approved on behalf of this pet that he purchased for Ms. Hodges. In addition to that, Judge, you're going to hear evidence that the parties fostered numerous dogs, several hundred dogs throughout their marriage. And at this point now, Mr. Hodges is saying he wants reimbursement for all those expenditures, which He was the individual that went and actually,
Objection, Judge. This assumes facts that are not in evidence and were not dealt with in discovery.
All right. Overruled. This is just argument of counsel of what he expects the evidence to show.
and Mr. Hodges was the one that encouraged the fostering and actually developed a relationship with the kennels and would foster the animals. So, Judge, I think once you hear the evidence and the evidence is presented to you, Judge, I think you're going to find that Ms. Hodges has not committed any waste of community funds, and in fact has basically worked with Ms. Hodges throughout the relationship and done what they both agreed was something they both enjoy, which is fostering animals and helping pets. So I don't believe that there will be any sufficient evidence to support Mr. Hodges' reimbursement claim. However, Judge, I do believe there's going to be sufficient evidence to support Ms. Hodges' request for reimbursement, as well as a waste and fraud on the community claim through the bank statements and evidence presented to the court here this morning, Judge. And based on the evidence I think we're going to present this morning and hopefully this afternoon, Judge, I think the court will, and I'm hoping the court will, grant a reimbursement claim for Ms. Hodges in the form of spousal support, award her separate property residence, Judge, award her the requested relief she's asking for, and her requested relief, which has been filed and is one of the exhibits marked for today, Judge. And with that, Your Honor, I will wait till I call my first witness.
Thank you, Mr. Zan. Ms. Phoenix, would you like to give your opening at this time?
Yes, Judge. May it please the court. What I believe the evidence is going to show this morning is not that Mr. Hodges wasted money. It's going to show that Mrs. Hodges is irresponsible with money. It's going to show.
Can Mr. Hodges turn his video on, sir?
Oh, yeah, I'm sorry. I meant to say that before she started her opening. Mr. Hodges, you're in court, so you need to have your video up and running.
I'm sorry, Ms. Phoenix, to interrupt you.
That's okay.
There we go.
There he is.
All right, Ms. Phoenix, you were, just to refresh your recollection, you were saying you believe the testament is going to show that Mrs. Hodges is irresponsible with money.
Yes, Judge. If you would, when you see her credit card statements, you will see that since they've separated and even before that, her credit cards are maxed out, Judge. She's had numerous jobs, a lot of different jobs, but she has very little retirement saved up. And during the pendency of this case, when the court said that you're not supposed to spend funds or expend funds unnecessarily, she has taken money out of her retirement. It's even less now than it was when the case started. Judge, she has no savings whatsoever. And Mrs. Hodges is about 50 years old and has had a lot of different jobs and makes good money. And Mr. Hodges has contributed to her financially, and she still has no money. She had to go to her mother to get money, and her house is paid for. So she's got a paid for house, no mortgage. She doesn't have any children, and she's not got one penny saved. And she took money out of her retirement during the pendency of this case. So she's clearly irresponsible with money. Her credit cards are to the max. And I believe the evidence is going to show that she's making this waste claim in an effort to put the squeeze on Mr. Hodges for money after this case is over. Because she's irresponsible and she wants money and she doesn't have a retirement and she's over 50 years old. Judge, the evidence will also show that her cruelty to this gentleman in divorcing him. She planned for the divorce while they were still in counseling. He was trying to save the marriage. He thought he had a chance. And as it turned out, she was setting things in motion to get rid of him. All he asked for was his stuff. He didn't want any fight with her. He just wanted his things. She did not give him anything. He left the house with the clothes on his back. So he had to buy all new stuff. The evidence is going to show that she was cruel in that she would not give him even his mother's things that he'd gotten before the mother passed away. She put his things on the curb for the garbage man to take. She gave his things to her friend for the friend to hide. So while Mr. Hodges is trying to get his things from her so he can move on, in her cruel black heart, she did not give him anything and she was hiding the few things he had. So Judge, this is not a case about this lady, Mr. Hodges wasting money. It's a case about somebody that's frivolous in spending, has overspent her entire life, and wants to continue that lifestyle after her divorce, and she believes she can do it by claiming that Mr. Hodges wastes money, and it's not true, and the evidence is going to show to the contrary.
Thank you, Ms. Phoenix.
And she extended the trial date, Judge. One more thing. This case, no kids, no community property to speak of. They've extended this case, Mrs. Hodges, long enough to get to that 10-year mark so that she could ask the court to give her spousal support. 10 years was last week. They modified, and now they're asking for spousal support. So as you can see, this has been a plan to take advantage of this poor man. And we ask that you not be a party to that, but that you find that there is no waste and award her nothing. Thank you, Judge.
Thank you, Ms. Phoenix. Mr. Zane, you may call your first witness.
Thank you, Judge. I would call my client Lynn Hodges, Your Honor.
You may proceed.
Thank you, Your Honor. Ms. Hodges, would you do me a favor, ma'am, and state your full name for the record?
Lynn Ann Hodges,
And Ms. Hodges, can you tell the court when you were married to Mr. Gary Franklin Hodges?
11/11/11.
Can you tell the court when you ceased to live together as husband and wife?
2/11/20.
And can you tell the court, has your marriage become insupportable due to discord or conflict of personalities that destroys the legitimate ends of the marriage relationship?
Yes,
Is it your belief that your husband has committed adultery?
yes,
Were any children born during this marriage, Ms. Hodges?
no,
Were any children adopted?
no,
Are you currently expecting a child at this time, ma'am?
no,
Is there any possibility of reconciliation between you and Mr. Hodges?
no,
And we've yet to go into your requested relief and the evidence presented, but you're asking this court, once we present the evidence and at the closing of this case in chief, to grant you a divorce and divide the assets and debts that you've requested. Is that right, ma'am?
yes.
All right. And Ms. Hodges, I want to go ahead and start addressing initially the reason why you filed for divorce. Can you tell the court what caused you ultimately to file your petition for divorce and start this divorce process?
Mr. Hodges moved out without ever saying anything to me. I came home from work and he was gone. I didn't hear from him for several days, but in the interim, I filed for a divorce since I didn't know where he was, what went on. He left no note, no nothing.
Are there any additional reasons why, other than Mr. Hodges leaving the residence, that you filed for divorce, ma'am?
Yes.
What are they?
He was committing adultery.
How are you aware that he was committing adultery?
It started with, I caught him at a woman's house for an hour and a half. I don't remember what the day was, but it's been a couple years now.
And what did you witness him doing while at this other woman's house?
He was parked in her garage and he came out of the garage. It was like a townhome situation where there was a common driveway for many units. And he was standing there in the door from the residence into the garage. She had on like a little bitty bathrobe and he was kissing her.
Did you confront Mr. Hodges at some time after this alleged incident that you witnessed about what you saw?
No, I confronted him about the condition of actually his underwear smelling like another woman.
And what was Mr. Hodges' response to your confrontation?
I don't want to say the exact words he used, but he said he was going to do his own laundry from then on.
Okay. Did he ever admit to you that he was having an affair?
No. He always
You
told me that if, and the whole time we were married, he always,
Non-responsive.
Sustained after no.
What did Mr. Hodges tell you, ma'am?
he always told me that if he ever decided to fool around, that I would never know that he was so slick at doing it, that he would never get caught.
What other belief other than what you witnessed Mr. Hodges kissing this other woman do you have to support your contention that he committed adultery, Ms. Hodges?
Pause for speculation, objection.
Overruled.
Mr. Hodges started changing his behavior. He changed the code on his phone, which for years we had an agreement that he wouldn't do that we'd have equal access. And in fact, for years we shared the same code. He started that after he started his business. He changed his behavior. Mr. Hodges used to wash his car once a year. He started washing it 2 or 3 times a week, as if he was like a young high school kid dating. He started coming home later and later. He wouldn't answer my texts or my phone calls. And one night I said to him, "Hey, I text you at like 12:30. This was 10 o'clock at night." And he said, I said, "I just needed like a 2-second answer." And his exact response is, "You can take it 2 ways. You can decide that I don't give an F about you, or that I was too busy to be bothered."
So Mr. Hodges' treatment towards you prior to you filing this petition for divorce, can you tell the court what it was like?
It was awful. I mean, like, we'd go to a UT tailgate, and several years ago, I had broke my leg while painting the trim on the house. I fell off a ladder, and we're walking to the tailgate, both carrying items, and I slipped on some rocks and fell. Mr. Hodges never even stopped to look back. He went on to the game like I wasn't even with him. When I was finally able to get up, I limped back to the vehicle, and I just stayed in the vehicle till the game was over. He never called, text me, came back to see if I was okay. And when he finally came back across the overpass to the parking, he said to me that I was lucky that he didn't leave me in Austin, but I was sitting in the vehicle. And he told me how I had ruined the game for him because everybody was asking
Object
where
to
I
the
was.
narrative, Judge.
Sustained.
He told me that I,
Hold on. If I sustain, that means wait for the next question.
Ms.
Okay.
Hodges, were you able to take any photographs or any actual physical evidence regarding the alleged affair that you state your husband was having with this woman who you witnessed kissing?
no,
So other than your belief in what you actually witnessed, there is no other supporting evidence for this court, is there?
no, sir.
Okay. But do you wholeheartedly believe that there was at least a minimum inappropriate relationship with someone of the opposite sex between Mr. Hodges and that person?
Absolutely.
I want to go down the line regarding your residence that you currently reside in. Can you tell the court when you acquired that residence?
I closed on that house June 22nd, 2004.
And in Mr. Hodges' inventory, as well as yours that we both stipulated to, it's acknowledged under separate property that that home is your separate property. Is that your understanding, Ms. Hodges?
Yes,
And when you married Mr. Hodges, can you tell the court whether there was a mortgage on the property or not?
no, there's never been a mortgage. I paid cash the day I closed.
And when you married Mr. Hodges, did you both live in that residence?
Yes,
And so what expenses did you and Mr. Hodges incur while residing in your separate property home?
as far as the house or just in general.
Just everyday expenses associated to living expenses.
Insurance, utilities, maintenance of the home. We had.
Are you aware that
warranty.
Mr. Hodges is asking for reimbursement regarding expenses associated with your residence, ma'am?
Yes,
Specifically, I'm going to pull up Mr. Hodges' inventory that he's filed with the court. And I'm going to pull that up. Give me one moment. And that is Respondents Exhibit 1, Ms. Hodges, if you don't mind pulling it up on your computer so you can go through it with me. And Judge, I'm referring to Exhibit R1 that's already been stipulated to and admitted into evidence.
I got it. Thank you.
You're welcome, Your Honor. And if you see Ms. Hodges under reimbursement claims, Mr. Hodges has put in that he's asking for reimbursement, and this is on the bottom of page 3 going on to page 4.
Okay.
He specifically states home remodeling. Are you aware of any home remodels that you've made to your residence since you've been married to Mr. Hodges?
No,
What could he possibly be referring to in regards to any improvements or remodeling made to your residence?
we did put in a laminate floor back in 2012, but it's in very bad shape and needs to be replaced.
You put in a laminate floor in what year?
2012, shortly after we started fostering dogs.
Okay. And what is the condition of the floor now?
It's an awful shape. 2 of the areas, one in the office where he used to sit and another one in the living room, because of the chairs and the weight, it has tore up all the finish on the laminate, and it's also started to separate. And then for some reason, some areas are just losing color. I'm not really sure what that's about.
In your opinion, do you believe if you were to sell the home that the flooring would provide any additional value to your residence?
No, in fact, I probably have to give an allowance for the flooring.
In addition to the flooring, were there any repairs made to the residence during your marriage to Mr. Hodges?
To the residence itself, no. I mean, he didn't like the color red, so I painted the room, some of the rooms for him and that type of stuff, but that was it.
Were there any repairs made to the outside lawn of the residence?
The backyard, from having hundreds of fosters, had become a bowl. And so anytime it rained, it was literally like a pond. And it was difficult for the fosters to, get around and such. So we regraded the backyard and had a sprinkler system put in, and they put in French drains so that the water would not accumulate and the dogs would not have to, basically live in us, because, it would rain for days on end, and they literally would only have the small edge, and the backyard is not very large. And then
So what improvement was done to, I guess,
they put in,
assist with that issue?
they leveled the yard and they put in French drains, and then they put in the sprinklers. Mike Ball.
And when was this done, if you recall?
That was done before Harvey. So
Was it done during your marriage to Mr. Hodges?
yes.
Okay. And how was that paid, ma'am? Who paid for that expense?
My mother randomly sends me checks. I haven't don't really know.
Objection not responsive.
Sustained.
Well, who paid for that irrigation? Did you pay for it, or did Mr. Hodges pay for it?
I did.
And what proceeds, what monies did you use to pay for that irrigation repair?
I used the money my mother sent me.
How did your mother send you the money?
She transferred $50,000 from her financial investment account to my checking account.
And which checking account was that to?
It was my primary checking. It's since been closed, but I believe it ended in 3320.
And I'm going to ask you to refer to what's been previously marked as Petitioner's Exhibit 42.
Okay, just a second.
And I'm not going to tell you I'm not asking you to tell us what's in it. I just need you to tell the court what it is.
Okay, hold on, let me get to 42. It's Petitioner's Exhibit?
It's Petitioner's Exhibit, our exhibit, yes. And Your Honor, just so the court's clear, I did submit this last night. It was inadvertently left off my exhibit list. So I sent this to the exhibits last night, submitted it to Ms. Phoenix. And my understanding is there's an objection because I did not submit it before noon yesterday. And so
It's-
I'm going to
Sorry.
go ahead and prove it up, Judge, and let Ms. Phoenix place
Yeah,
her
we'll deal with,
objection.
we'll deal with the objection once it's offered. So
Oops, sorry.
I noticed that I have the exhibit, so you can go ahead and proceed and then we'll take the
Thank
objection.
you. And
And
can you have it in front of you, Ms. Hodges?
Yeah, what number is it again, 2?
42. 42.
Oh, here it is. Okay.
And I'll ask that you open it up and then just tell the court what that document is, ma'am.
It's a document. The first document is the bank statement in which the money was transferred.
Okay.
And it shows
what bank account is that for?
It's for my checking that ends in 3320.
And you stated that is a Wells Fargo bank
Yes,
statement?
it's a Wells Fargo bank statement dated November 7th to December 6th, 2018.
And to access any bank statement through Wells Fargo, how do you access those records?
Well, this I actually had to go to the bank and get, but I normally access it online.
Okay. And is that an accurate depiction of your account ending in 3320?
Yes,
And to your knowledge, is that a record that's kept in the normal course of business associated with your banking?
yes,
And has that document been altered in any way to your knowledge?
no, sir. Well,
Was that
except for
an
the highlighting of it that you did, but that's it.
Has that altered the document in any way, though?
No,
And that record is something that's kept, well, I've already asked that question. So, Your Honor, at this time, I'm going to offer the Exhibit 42, which is Ms. Hodges' Wells Fargo bank statement for account ending 3320.
Ms. Phoenix?
Judge, I'm looking at this exhibit. It looks like I'm objecting to it, Judge, first of all, because it was late. And second of all, it looks like it was the 25. It looks, Judge, like it's $25,000 that's at the end of this. I'm not sure what, is there 225s?
We can get into that if the exhibit gets in as far as the details of the exhibit, but when did you receive the exhibit, Ms. Phoenix?
We received it last night. Let me look, Judge.
And Judge, just for clarity, it is a document we submitted in discovery responses.
8:40 PM, Judge, it came in.
All right.
And
Well,
so of course
based
I
on-
didn't see it until late. If I was up late, so I happened to see it, but it was late filed.
I understand. It sounds to me like it is an exhibit that would be potentially in response to a claim that was made by Mr. Hodges that there's a reimbursement claim on his inventory. So it sounds like this exhibit could come in as rebuttal evidence. I know he hasn't testified yet, but I don't see that there's any harm in admitting petitioner's exhibit number 42 or any surprise. So the objection to petitioner's 42 is overruled. Petitioner's 42 is admitted.
Thank you, Judge.
May proceed, Your Honor.
May.
Thank you, Judge. And Ms. Hodges, exhibit number 42, which has just been admitted into evidence, can you tell the court, after looking through that document, where and when did your mother provide you the $50,000 that you're saying you used for the irrigation repairs?
oh, let me go back to the document. Hold on.
I'll ask you to just refer to page 3 of 6 specifically. Can you tell us
11.
when you received the money?
11/28/2018.
And how was that money sent to you?
It was transferred from a Wells Fargo investment account that she has to my checking account.
Okay. And it's your testimony that you used those funds to pay for the irrigation repairs that
Yes.
were performed for the yard at your residence?
Yes.
Okay. In addition to those repairs, were there any other repairs or improvements made to the residence, such as HVAC, plumbing,
Yeah.
anything of that nature?
Right. The heating and the air conditioning unit had to be replaced.
And how was that, when was that replaced?
It was also in 2017 or 18. I can't remember which. It was either 17 or 18 years old.
And what was the cost of that replacement, if you recall?
I believe it was a little over 12,500.
And what funds did you use to pay for that replacement of the HVAC unit?
The same funds.
Okay. So if you received the funds from your mother in November of 2018, would the repairs for the HVAC come after that?
Yes.
Okay. Did any community funds, I mean, income that you've earned during the marriage from your employment or for Mr. Hodges' employment, were those used to pay for the irrigation or the HVAC?
No.
100% of those funds from your mother were used to or applied towards the irrigation and the HVAC replacements and repairs?
Yes.
Ms. Phoenix had asked a question earlier regarding the check at the bottom of this statement. Can you tell us what that is?
Yes, my mother in March of this year sent me a check for $25,000.
So that's a separate check. That's not associated with the $50,000 that's in the bank for November 18th.
Correct.
So in addition to the $50,000, your mother sent you an additional 25. Is that right?
Yes, sir.
Okay. And she actually mailed you a check. Is that
Yeah, that was actually a mail check, right?
Okay. So in total, can you tell the court how much money your mother has sent you since you've been married to Mr. Hodges?
$75,000.
And the $75,000, other than the irrigation repairs and HVAC repairs, what did you do with it?
I spent it on expenses, the fosters, paying off some bills.
You've heard
Justice.
the testimony from or the opening statement of Miss Phoenix regarding the fact that you've had numerous jobs, you've maxed out your credit cards, you've got very little retirement, and you're basically living off the money sent by your mother. You recall hearing that?
Yes, sir.
And let's address the numerous jobs. Can you tell the court if you've had numerous jobs?
I've worked for the city of Houston since 2007.
Objection, non-responsive.
Sustained.
How many jobs have you had during your marriage to Mr. Hodges?
I've had the same job, 3 different positions.
Okay. So have you been employed with one agency or one employer since your marriage to Mr. Hodges?
Yes, the city of
who is that?
Houston. The city of Houston.
So the statement that you've had numerous jobs, is that accurate or inaccurate to your knowledge?
That's inaccurate.
Okay. If you've only been employed with the city of Houston, have your job roles changed with the city of Houston?
Yes.
What is your current position with the city of Houston?
I'm a financial analyst 3.
And what is your current income?
70,005, I believe.
Can you tell the court, let's go down to the next statement, that you've maxed out your credit cards. Can you tell the court if that's an accurate statement?
Not exactly, but I do have high balances on them.
And why do you have high balances on your credit cards?
Well, a great deal of it was to maintain the house while Mr. Hodges was there. And then since then, I've had expenses, yours being one.
Have you expended quite a bit of money in legal fees throughout the process of this divorce, Ms. Hodges?
Yes, a great deal.
And you're not asking that Mr. Hodges be responsible for any of your credit card debt today, are you?
No.
You're asking that you be awarded that debt, correct?
Objection from
Yes.
leaving.
I'm going to allow it since it's requested relief. So overruled.
Thank you.
You've heard the statement that there's been very little retirement in your retirement accounts. Can you address that if you know?
Well, my retirement currently stands at just short of $2,000 a month with 14 years of service. It shall increase over the next several years. As far as my deferred comp, I had to borrow money every year up until he moved out to pay our joint income tax because he paid virtually no income tax during the year except for what came out of his military retirement. But when you have a six-figure income like he does, and you don't pay taxes all year long or less than 2,000, someone has to pay the taxes, and he simply refused.
Okay. So it's your testimony that you've had to borrow money from your retirement to pay IRS tax debts that were an obligation of the community estate?
Yeah, partly, and then partly was yours.
You borrowed money from your retirement to pay my fees as well?
Yes.
Okay. So the money that you took out of your retirement account was not used for, let's say, going out to eat or lavish vacations?
No, I haven't been on a vacation in years.
When's the last time you went on a vacation, Ms. Hodges?
2014.
Okay. So you haven't expended any funds since this divorce was filed on any vacations or lavish expenditures, have you?
No.
Tell the court what you primarily expended money on since filing for this divorce.
Justice. Justice had cancer back in.
Can you tell the court? Can you tell the court who Justice is?
I'm sorry, what was the objection, Ms. Phoenix?
That's okay. Oh, that's okay, Judge. I'll withdraw that. Sorry.
Justice is the chocolate lab that he gave me as a gift in Christmas of 2008.
Okay. And you said that you spent quite a bit of money on Justice, right?
Yes, she said when we were.
Objection, non-responsive after yes.
Sustained.
Why have you had to spend what you state is quite a bit of money on Justice?
She has cancer and she required surgery and treatments and special food. And she also is going to be 13 next month. So she has, arthritis. She was quite an athlete when she was younger. Did a lot of dock jumping.
When did you acquire Justice?
Well, I actually got her as a gift in December of 2008, but we weren't able to pick her up because she was just barely born till February of 2009.
And who gave you Justice as a gift?
The respondent.
Mr. Hodges?
Yes.
And at the time that you acquired Justice, was he aware of the expenses related to a dog, owning a dog?
Yes, because we had talked about it in between the time that he gave me the note that said he was going to give her to me and the time we actually picked her up and how she should be treated. And
when did you become aware that Justice was diagnosed with cancer?
I believe it was August of 2018, August or September.
And were you and Mr. Hodges cohabitating as husband and wife at that time?
Yes.
Was he aware?
We were both pretty upset about, the cancer diagnosis.
So Mr. Hodges was also aware of the cancer diagnosis?
Oh, yes.
And was Mr. Hodges in agreement with the expenses related to cancer treatment for Justice?
Yes.
At any point in time during your marriage to Mr. Hodges, except for today, were you aware that Mr. Hodges was seeking a reimbursement for expenses related to Justice?
No, just through this divorce process.
In fact, during your marriage, did y'all, I wouldn't say own other dogs, did y'all have other dogs in your household?
Yes, in March or April.
Objection, non-responsive after yes.
When did you have other pets in your household?
In March or April of 2012, we started fostering dogs. And initially we just had one. And then after that, we normally from 2012 till like October or November of 2018, we fostered about 400 dogs and puppies. We typically had 7 to 10.
Sorry, did you say 400?
Yes.
Okay.
And the 400 dogs that you approximately fostered during your marriage with Mr. Hodges, can you tell the court what whether Mr. Hodges was in agreement with that or not, if you know?
Oh, yes. In fact, he used to, because of his traveling with the process serving, he had all the connections with the shelters. So he would go to say like the Pasadena shelter, and he had connection with the staff. They would call him and say, you know, a litter of labby puppies is going to be, you know, turned in, or they got him in, or, you know, that type of thing. And he would actually be the one that went to the shelters. I had a hard time going to the shelters and remembering their faces. So he, majority of the time, picked up whatever dogs we were, or dogs and or puppies that we were going to foster, and brought them to the house.
You understand in Mr. Hodges' inventory and his requested relief, Ms. Hodges, that Mr. Hodges is requesting a reimbursement claim for pet expenditures.
Yes.
You believe that that is an appropriate reimbursement that you should make to this community estate, ma'am?
No. And the reason,
why do you believe it's not appropriate?
the reason is that when you have basically, you know, 18 to 20 dogs in your house, including, you know, in that number, a litter of puppies, our dog food bill a month was well over $1,000. And then the rescues only pay for the vet care itself. So puppy pee pads, toys, treats, there was a lot of medicine that we used over the counter, like baby vitamins and, you know, Blue Star ointment if they had rashes, or, you know, whatever it was that they needed at that moment in time, special formula for the puppies that we supplement, because lots of times we would get them when they were like barely 2 weeks old. It costs a great deal. And the income that Mr. Hodges gave did not cover that, as he states.
Can you explain to me, what do you mean income that Mr. Hodges gave?
He would give me money every month for expenses or whatever. He never designated what the money was for, but I used it all for the dogs. Ours, you know, at the time we just had one. And then, you know, as the fosters came and went.
Can you tell the court if Mr. Hodges ever expressed to you a disagreement or I guess an objection to expending any community funds on these foster dogs or your own dog, Justice, for that matter?
No, never. And in fact, lots of times he would, you know, bring home a special toy or a special collar, even because we had to, you know, put collars and tags in all of them. He would see a collar that, you know, he thought fit a particular.
Objection, non-responsive, Judge.
Same.
Mr. Hodges is also alleging, Ms. Hodges, that you've committed wasteful spending during your marriage with Mr. Hodges. Are you aware of that, ma'am?
Yes, yesterday I became aware of it.
Do you believe that purchasing a wardrobe, clothing for your employment is wasteful spending?
No.
Have you, in fact, committed any wasteful spending to your knowledge, ma'am?
No.
What I want to go through just very briefly, Ms. Hodges, the exhibits that have been offered by opposing counsel and admitted in evidence, which are respondents' records.
Okay. All right.
And specifically the bank records. And I'm not going to go all the way back to the time of marriage. I want to go to recently, which would be 2020, after your divorce was filed. So I want to ask you to refer to respondents exhibit number 16.
Okay, hold on one second. I got to get back. 16?
Yes, ma'am.
Okay.
Actually, that's the incorrect one. That's the wrong bank account. It is, let me get the right one. It's exhibit number 14. I apologize.
Okay, hold on.
Just let me know when you have it up, ma'am.
Yeah, it's taking it a minute to load. I don't know why.
And Judge, I know we're running short on time for lunch. If I can just get through this one exhibit with the witness, then I'll be, I think that'll be a good stopping point for the court.
That's what I was going to do. I had the people I told you about earlier, they just showed up. So I'm going to break here once we get done with this exhibit for lunch, and we'll resume at 1:30. But let's go ahead and get the exhibit.
Sorry.
Yeah,
Okay,
you have it
I'm
up,
there.
Ms. Hodges? Okay.
Yes.
And that is you and Mr. Hodges' joint bank account ending, or joint bank statement ending in account number that is 3320. Is that right?
Yes, sir.
Okay, and this is for statement January 7th of 2020. When did you file for divorce, if you recall?
2/13/20.
Okay, so this is the month right before you filed for divorce, is that right?
Yes.
Okay, and I want to go into the bank records beginning on December 6th of 2020. Can you tell the court what that is? It's an ATM withdrawal, right?
Yeah, for $100.
And are you aware of that ATM withdrawal?
I mean, I'm aware that I did it.
Do you have any
I'm
idea
sure.
why you would take money out through an ATM?
For lunch and expending money, like, snacks or whatever.
And this was done on Smith Street in Houston. So is that close to your place of employment?
That's the closest Wells Fargo to my office, yes.
Okay. And it's your testimony that you would go to the ATM to take out money for lunch?
Yeah, I mean, it depends on where you went, because some places, like some of the food trucks and things around there, only take cash
Okay.
and don't take credit cards.
Then they have highlighted on this December 9th statement an e-deposit. You know what that is?
No, I do not.
Okay. And then you see all these highlights in pink, and that's what they're saying should be reimbursement claims.
I know. Now, the ones that are on, the first ones that are for Mud and Grand Mission, those are the property taxes and the HOA dues while Mr. Hodges was living in the house.
So you're aware that he's asking that he should be reimbursed, or the community should be reimbursed for mud taxes, for HOA fees, for basically any expenditures on the home. Are you aware of that, ma'am?
Yes.
And it's your prior testimony that there was no mortgage, so no community funds were ever spent for a mortgage payment. Is that right?
Correct.
Okay. And in addition to those expenses, on December 9th, he's asking for a reimbursement claim to Wolfgang Bakery. Can you tell the court what that is for?
That's where dog justice has to have a special dog food that is only sold at specialty stores. Once they have cancer, they can't have carbohydrates. So that and her treats are purchased at Wolfgang. I do get a 20% discount there.
Had you purchased items at Wolfgang prior to Mr. Hodges moving out of the residence?
Oh, yes, the whole marriage. I'm not exactly sure when Meredith, my friend, bought that store, but ever since then. So yeah, for years.
So he's been aware.
Yeah, he used to buy stuff at that store and go stop and visit Meredith.
Okay. And you see down below another Chewy.com expense, and I'm assuming that's for Justice as well?
Right. There's special vitamins that she takes called Ficox that she's been taking since she's a puppy. And then these cranberry ones because she had a round of urinary tract infections that I purchased from Chewy.
I'm not going to go through every expense that they highlighted in pink, but if you'll look, glance through them, you'll see, are most of these expenses on behalf of Justice, purchased items on behalf of Justice?
Yes, like there's one down in 1216 that's daycare. She's been going to that daycare since she was a puppy, like literally like 4 or 5 months old.
Okay.
We used to take her twice a week, but now that she's older, she has difficulty going twice a week. So she still goes once a week.
So you would agree with me if we total the reimbursement claims that Mr. Hodges has on this one statement alone, a majority of them, if not all of them, are for mud taxes or taxes related to the residents or expenses related to Justice. Is that your understanding?
Yes.
And do you believe that those reimbursements are warranted and valid?
No.
And are you asking the court to deny his requested relief for reimbursements related to mud taxes or HOA fees associated with the residents?
Yes.
And are you asking for the court to deny Mr. Hodges' request for reimbursement related to expenses associated with Justice or any of the foster dogs that you and Mr. Hodges fostered?
Yes, because he was perfectly in agreement with them till he moved out.
And Judge, I think that's a good stopping point for now.
All right, let's go ahead and break for lunch. We'll resume at 1:30. We're going off the record.
Thank you, Judge.
And Ms. Phoenix, if you'll let me know about Ms. Coe, and let's see if we don't hear back from her by 1:30. All right, thank you.
Thank you, Judge.
We'll see if we see him.
Judge,
Yes.
I believe the young lady is gonna be calling you on that phone number. She just gave us a call.
Okay.
She just left the doctor's office.
Okay.
Okay, so we'll see if she
We'll put her
calls.
on, we'll put her on speakerphone, and I think Mr. Zan's just joining us. So we'll put her on speakerphone when she calls in and see what the status is.
What, she sent a text?
But she called her, those sons go.
Oh, she just called. So we did talk to her.
She's pissed.
Whoops.
Afternoon, Judge.
Good afternoon. You were joining when Miss Phoenix was telling me that this witness, I guess, called her office, or they spoke to her. She's just now leaving the doctor's office. So she's supposed to call in to the court. And what do you want to do, Mr. Zan?
Judge, in all honesty, based on the time constraints we have, I just want to be honest with the court. I don't know that we're going to be able to finish this case today. I just don't see it possible with 3.5 hours remaining in the day. And I still have to get through my witness. And I know Ms. Phoenix hasn't even called her client, nor have I questioned him. I don't see it practically capable of being finished today.
Well, I told when Judge Heppard came in, that's kind of what I told her. We got a later start because of the witness issue. And, but that being said, it's going to be pushing it to finish today.
I'm depressed.
Well, she was going to send me a protective order at 4 o'clock. And I said, I can promise you we'll get me done by 4.
I don't want to hear that.
So what we could do potentially is maybe have this witness appear tomorrow morning at 9. If that works better for you, Mr. Zan. I don't know. I just, as soon as I talk to her, we'll know more.
I have a temporary orders hearing set in Harris County tomorrow, Judge, that has been pending since March. So I've tried to get dates, and this is our only date that we have, Judge, and it's an issue with possession and access on a temporary. So I don't know that I could push. I can't miss that.
Well, I mean, I'm not gonna have you do that. So we'll work on calendaring if it looks like. Probably what we'll do is at our afternoon break, if I can tell from the pace of the testimony that we're gonna need more time, I'll deal with that when we come back from our afternoon break and get a idea when we can come back. It'll be quickly though, because I want these parties need this to finish, and I want to do it while it's all fresh in everybody's mind as well. So it'll be fairly quick, but we'll figure that out this afternoon if we need to.
Understood.
Miss Phoenix, this lady still hasn't called in.
We'll check with her, Judge. Hold on. Let me get myself muted.
Judge, I was thinking if this is an issue with the witness, then I mean, she can always appear, call in later, and we can have her sworn to appear if this case is not going to be completed today, so that we can at least get started with this and get this thing moving versus another 30 minutes elapses and we're wasting time.
Yeah, we it would have been nice to know the conflict earlier, but it is what it is.
Like you said, Judge, I think people just disregard subpoenas and the importance of court and just don't take it serious sometimes. And I understand people have issues, but communication would assist a lot of that.
Well,
Just last week.
Judge, she just got subpoenaed Friday, so I
Yeah.
know, yeah, I know.
Yeah, that's a problem, you know, I mean, I get it. If she was subpoenaed Friday and perhaps she, you know, didn't realize there was a conflict immediately, and then when she did realize it, it was, you know, Monday, and here we are on Wednesday. So but you know, if we know about that stuff ahead of time, the court can accommodate people and accommodate lawyers so we don't have dead time like we've had, you know, today. But let's go ahead and we're gonna go ahead and get started because I'm not, we're gonna have to get her in at some point. But I'm not, unless we know she's calling right now, I'm inclined to go ahead and get back.
We
on-
thought she was calling, Judge. She said she was gonna call, but she was just leaving her appointment. So I don't know if something stopped her or what, but she gave us the impression she was getting ready to call, which
Okay.
is why I told you
Yeah.
that she was
Well,
getting ready to call, so.
And it may be we just need to wait until she gets home and we'll deal with it once she
Yeah.
gets home and
Yeah.
she can be at a phone where she's not driving. So
She said
let's
she
go
has a
ahead.
brain tumor, Judge, so she might be awfully upset too.
That's what they told her today.
Well, she sent us a text over the lunch hour and said she has a brain tumor. So I don't know if she was just saying that or if that's what they told her, but
Well,
that's
you
what
know,
she told us.
I'll tell you, Mr. Zan, that's another thing where if all that's, you know, all that's accurate, it may be a witness that unless it's really somebody you absolutely need that you might, I'll let y'all make that decision after y'all hear from her. But yeah, if that happened today, that's a lot for that lady to go through and then be testifying. All right, so let's go ahead and get back on the record. Court's back on the record in cause number 20 DCV 271334. Ms. Phoenix, I need you and Mr. Hodges. Okay, is he going to be on the screen with you? That's fine with me, if he prefers that.
Yes.
We're back on the record in the Hodges matter. We're going to pick up where we left off. We were on the direct examination of Ms. Hodges by Mr. Zan. Mr. Zan, your witness.
Thank you, Judge. Ms. Hodges, good afternoon, ma'am.
Good afternoon.
We had just finished going through one of the Wells Fargo checking statements from account ending in 3320, dated January 7th of 2020. And we were addressing the alleged reimbursement claims by Mr. Hodges, the respondent. And so I'm moving down the line, and I'm going to try to go through this as quickly as possible to the next statement, which is dated February 6, 2020, in that same exhibit, which is R14. Do you have that pulled up in front of you, ma'am?
Yes, sir.
Okay. And you see that, once again, they've got highlighted several things within that monthly statement. Are you able to see those pink highlights?
Yeah, the first one is an ATM withdrawal for $100, that one?
No, the pink highlights.
Oh, I'm sorry.
Are you on page 2 of 5 for the monthly
Yeah,
statement?
the
of
first
February
is
6th?
dated 12/9.
I think you're on the wrong month. We're
Oh,
going,
okay. Yeah.
it's actually page 8 of 45 within that
Okay.
exhibit.
Let me go down. Okay, I'm on 8. The first
Okay.
one is Kingsland Boulevard. That's Justice's regular vet. That
Okay.
one.
Yep. And then you see other highlighted
Right.
in pink.
There's
And Wolfgang.
Wolfgang.
What is that?
That's again, dog food, special dog food and treats.
What's the one on 115 air specialist? Can you tell the court?
Yeah, there's a annual service fee for the heating and the air conditioning to service. That includes the spring and fall check for the heat and the AC unit. It's an
Is
annual
that
fee.
maintenance on the residence?
Yes.
Okay.
Mhm.
And then the following highlights on 121, can you tell the
Are
court
all-
what those are?
Those are all taxes and HOA dues.
How do you pay your taxes associated with the residence?
Usually via bill pay.
Are they paid
Wells Fargo
quarterly,
bill.
weekly? How often do you pay?
It depends on how they're billed. Sometimes depending on how much time is left when they send the bill out, I may divide it or I may pay it all at once. It just depends.
Okay.
The HOA dues total for a year are $875 now.
All right. And then going down, you see additional highlights, and you would agree that a majority of those, if not all of them, are associated with justice.
Yes. Chewy's, Demi's, there's
Okay.
another one for taxes. Yep,
Okay.
they're all justice.
And so moving down, and I'm just going to ask you to basically summarize the statements regarding specifically the pink highlights throughout this entire exhibit regarding their
Okay.
requests for reimbursements. Can you tell the court what a majority, if not all of these requests for reimbursements are related to?
All related to justice and or the HOA and mud taxes included, but regular property taxes, that's all they are.
Okay.
There's
Are any
nothing
of
else
these
outstanding.
in relation to any reduction of principal balance of any mortgage on your home?
No, they're not, because there is no mortgage. There never has been.
Are any of these reimbursements listed or highlighted here related to lavish expenditures you've made?
No, in fact, in the course of business.
Objection, non-responsive after no.
Named after no.
What, in your opinion, Ms. Hodges, are their reimbursement claims related to, ma'am?
The 99% of them are either expenses for justice or the mud and or the property taxes and the HOA dues.
And let's go on to justice very briefly. Does justice have pet insurance?
Yes, she does. She's had pet insurance since she was 10 months, well, about 10 weeks old.
And what does the pet insurance provide?
It provides basically, in human form, we call it major medical. So anything that's above and beyond routine care of a dog, like shots, heartworm medication, it doesn't cover that kind of thing, but like surgery, something that isn't routine, like arthritis thing, cancer.
So you've had an opportunity to look through these statements, and is it your testimony that you're not aware of what every
Objection leading.
Just saying.
Do you know what every deposit in these statements is for?
No, however.
Objection after no.
Why don't you know?
Because there are so many of them. And also Pet Plan reimburses for about half of her life. They've reimbursed at 100% minus the $400 deductible per incident. And then insurance changed about halfway through and they reimburse at 90% minus the $400 deductible. So while you see the expenses here, many of the deposits are Pet Plan's reimbursement for a bill that was previously submitted. And sometimes the bills take 60 days to reimburse. So it has to be paid up front at the vet, obviously. And then later on, the deposit would come in. They literally just in the last few months have started e-deposits where they transfer the money.
Hold
So
on,
is
hello? Hi, Natasha. I'm on the record in trial, but I'm going to put you on speakerphone so we can address the subpoena issues and what, if anything, we can do to accommodate you as far as testifying. So give me 1 second because I don't want to have a conversation without the lawyers hearing it. So in 1 second, you'll be on speakerphone. If I can figure out how to work this phone. Give me 1 second. With the speaker with the arrow to it. Can you hear me, ma'am? This one. All right, Natasha, can you hear me?
Yes, I can.
Okay, so if I hang this up, it's not gonna hang up. All right, I've got both lawyers in front of me. They're on a Zoom call. And I don't want to get into too much detail about medical issues, but my understanding is you had a doctor's appointment today. Is that correct?
Yes, I've been gone all day. Yes.
And so the issue is the lawyer said, the lawyer that subpoenaed you says you're a witness to their case and that they need you to testify. And so you're under subpoena to be here today at 9 a.m. And I understand if you had a conflict, the best thing to do if that happens is to contact the court and let the court know, or contact both lawyers and let them know you've got an issue.
I did contact them. I have a brain tumor, so sudden thing, so I had to be at the med center today. I didn't have a warning. I
Did-
contacted the attorney on the opposing side at 6:30 a.m.
Oh, is something that happened this morning?
It happened a couple days ago, and I didn't realize that the med center wanted to see me today. So I contacted them at 6:30 this morning and told them I had an appointment. When I signed the subpoena, I didn't know that yet.
Oh, I see.
It was
So,
it was suspected brain tumor, but when they looked at my results, they had me come in today.
okay. All right. So at the time you got the subpoena, you did not know you were going to have a medical appointment today. Is it, that's what you're telling me?
Not this soon. I thought it was gonna be a couple weeks out or so.
Okay. All right. Mr. Zan, do you have, well, let me ask you this, Ms. Coe. I don't know how important a witness you are because I don't know anything about your testimony, but there's a subpoena from Mr. Zan. It doesn't appear like we're going to finish the trial today, so we may be rescheduling this for one day next week. Is there a certain day that you're available? He told me your testimony would take about 10 to 15 minutes. So is there a certain day next week that you're available to actually testify?
No, I think my other testing is done in the next couple weeks. So next week is fine. I feel like, can I speak freely or no?
You can, ma'am. I understand you're going through a lot, and I get that. But you also have to understand, as a judge, I have to follow the law, and I've got a subpoena here, and so there's, as a judge, I have an obligation to enforce the subpoena if that's what I'm being told to do. And everybody kind of got hit with your situation this morning. So I can tell you the court feels for you, and I can't imagine what you're going through emotionally. But that being said, I don't know how important your testimony is, and I have to accommodate this lawyer if he wants you as a witness, but you may speak freely.
Frankly, I just feel like I'm being harassed by Lynn Hodges and her lawyer. I've already did a deposition for an hour before, so I don't know how much more testimony I have to give. But if they need to talk to me again, the sooner the better. Is perfect for me because I have a lot of testing coming up, and I don't want to have to reschedule my test for the surgery that I have to have. So,
well, let me
Judge,
ask you
I'm happy
this.
to offer her deposition's been admitted. If the Joyce will agree that her deposition can take place for her testimony and the court can use that for purposes of her testimony, I'm happy to use that, Your Honor. And in lieu of testimony, I would offer her deposition in basically as an unavailable witness, essentially.
Ms. Phoenix, do you have any objection to using Ms. Coe's deposition testimony rather than her having to testify?
No, I'm not opposed, Judge. I read the deposition. Didn't have a problem.
And y'all have a transcript of it, Mr. Zan, that you can offer?
Judge, we have submitted that as an exhibit, which is marked as our exhibit. Looking for it. Thought we marked it. No, maybe we have not submitted it. We just submitted Mr. Hodges, but Judge, I can submit the transcript from the deposition for Ms. Coe in lieu of her testimony.
All right, well, if both lawyers agree to that, then I'm going to release her from the subpoena and let her focus on what she needs to focus on. So it sounds like both lawyers agree that the deposition of Ms. Coe can come in as petitioners, and we'll mark that as petitioners 43. We'll have you, I'll need you to submit that to the courts because I don't have a copy of it yet. But if that's the understanding, I'm going to let her go. So Mr. Zan, well, I'll go to Ms. Phoenix first since he's muted. Ms. Phoenix, you're okay with petitioners 43, which would be Ms. Coe's deposition testimony.
Not a problem, Judge. No objection.
All right. Mr. Zan?
Yes,
there's
Judge.
a stipulation from Ms. Phoenix that if you offer petitioners exhibit 43, which is Ms. Coe's deposition testimony, that she has no objection to it. So is that
Thank
what
you,
you're doing?
Judge. Yes, Judge, I just instructed my legal assistant to mark it as exhibit 43, submitted to the court as well as Ms. Phoenix.
All right, petitioners 43 is admitted.
Thank you, Judge. Um,
All right, just told the witness that, that she's released from the subpoena. We're back on the record. We're going to pick up where we left off. And we're going to resume the direct testimony, Ms. Hodges. You may proceed, Mr. Zan.
Thank you, Your Honor. And I think we were talking about the reimbursement from insurance for justice, Ms. Hodges, before we were interrupted regarding Ms. Coe. So you were saying that, just so I'm on the clear, insurance for justice reimburse for expenses that you've incurred for what type of expenses, ma'am?
What you would consider major medical. It doesn't reimburse, like I said, for routine, annual shots, heartworm medication. It's basically anything that's not a routine medical condition, like her arthritis, the ongoing cancer, checks, all of that stuff. It does reimburse for those, but not the routine stuff.
So does it reimburse for a majority of the, I guess, the higher costs?
Oh, yeah, for sure.
Procedures?
Mm-hmm.
And so you stated earlier as well that some of these e-deposits, you believe, are reimbursements from the insurance company for expenses related to justice's care.
They pay both ways now, that they would send me a check, or they're doing e-deposit now. So it's a combination of both.
So the expenses that you've incurred for justice that have been highlighted by Mr. Hodges in your Wells Fargo statements, have you truly incurred 100% of those expenses, or have some of those expenses been reimbursed?
They've been reimbursed. The greater share have been reimbursed.
Okay. So if the court were to entertain Mr. Hodges' claim for reimbursement regarding expenses related to justice, would the reimbursement request by Mr. Hodges be accurate based on the highlighted amounts he has within your Wells Fargo statement?
No, not at all.
And why would that not be accurate?
Because when you're being reimbursed, it zeroes out it as an expense. So you would have to take a good majority of the deposits, separate from my payroll, obviously, and take that off the dog expenses.
Okay. Let's move on to the respondent's exhibit number 15.
Okay, just a second.
And once again, that's your Wells Fargo. I think actually I don't want to go back that far, so it's not exhibit 16 that I want you to look at. It's,
okay.
It's 16. It's marked as 2020. Yes. Okay. Wells Fargo account ending 8651 is respondent's exhibit number 16.
Okay. Account number 3593.
That
ending
is
in
correct.
3590. Okay.
No, I have Wells respondent's exhibit 16 is ending in 8651.
Oh, wait, this is still 15. Hold on. I'm sorry. Okay. I have it.
All right. And I want you to look through that bank statement, which actually it doesn't provide any reimbursement. So I strike that question.
Well, actually it does. Oh, okay. No, it does. Deposits, right. So just go down.
I'm trying to locate the next one that had the okay. It's actually 17. It appears it's account ending 8758 for October 30th of 2020.
Okay.
And can you tell the court what account this is?
Hold on. It didn't load yet. Just 1 second.
And just so we're clear, we're looking at respondent's exhibit 17.
Okay. Dated October 30th, 2020.
Yes, ma'am.
Okay. Yes, I have it.
Okay. And if you look at the requested highlighted reimbursement claims, once again, in this statement, can you tell the court what a majority of these are for?
The beginning ones are for taxes, property taxes. Again, Wolfgang, Gulf Coast Veterinarian. they're the Gulf Coast is where she had the big cancer surgery to remove 2 of her toes. Those are all the follow-ups, another mud tax. That's it.
Okay. So after reviewing this Wells Fargo statement, can you summarize what you believe a majority, if not all, of these reimbursement claims are related to for the court?
The majority are related to Justice's expenses for her cancer treatment.
And in addition, are there any other?
Yeah, well, there's some deposits marked.
Well, I'm not talking about the
Okay.
highlights. I want to
Yeah,
talk
that's-
strictly
and
about the
there's-
pink highlights.
Yeah, the rest are for property taxes and
But none of these are for unnecessary expenditures or any expenditures that would be in violation of any injunctions that this court instituted, would they?
no. And in fact, her cancer treatment went on all during the marriage.
Objection, non-responsive, Judge, after.
Sustained after no.
When you and Mr. Hodges were living together prior to the filing of this divorce, Ms. Hodges, was Justice undergoing cancer treatment?
Yes, she was.
Did Mr. Hodges consent to that treatment?
Yes, he did. And in some cases, he actually dropped.
Objection, after yes.
Sustained after yes,
Non-responsive.
he did.
Would Mr. Hodges transport Justice to obtain the treatment?
Yes,
Would he actually pay for it himself out of
No.
y'all's joint account?
no.
How would it be paid when Mr.
I would
Hodges?
pay for it when I picked her up. He never paid.
Would he ever pick her up?
Maybe once, but the vet didn't make him pay. I paid the next time I took her.
And when Mr. Hodges was able to view or strike that, did Mr. Hodges ever speak with you about the expenses you were incurring for Justice's treatment during your marriage?
Never. In fact, like when she
Objection, after never.
Sustained after never. Ms. Hodges, your lawyer knows exactly what to pull out of you. I know it's frustrating.
Okay.
Want to just have a conversation, but it's real
Sure.
important. Just listen to the question that's asked and only answer the question that's asked. He'll pull the information out of you that he needs to get out of you. The other thing is, and this is for both Mr. and Mrs. Hodges, I normally give these instructions at the beginning of the trial, but it's also very important because we have a record that's taking down everything that anybody says during this trial, that you wait for the lawyer to finish his question or her question before you start giving an answer, because it could be that there's a court reporter that has to take a record down of this, and we want to make sure we're just talking one at a time and not talking over each other. And it also makes it easier for me to follow the evidence if we're just talking one at a time. So that's just a reminder for both parties to make sure you let the lawyer completely finish the question, and then you start to give your answer. And then the same thing for the lawyers. If they're giving an answer, wait for them to give their answer before we start asking our next question. And any witness that hears an objection, please stop talking until I get the rule on the objection. All right, Mr. Zan, you may continue.
Thank you, Your Honor. And so regarding the expenses for Justice during your marriage, Ms. Hodges, I previously asked you if Mr. Hodges ever approached you and informed you he was opposed to those expenses, and you stated, I'm sorry, can you repeat your answer?
Never.
Okay. And Mr. Hodges, at the time that you were still cohabitating with him, had equal access to this bank account that your names are both on. Is that right?
Yes, he's a signatory. Or yes, sorry.
And to your knowledge, he was able to access this account and view what transactions and expenses were being incurred.
Yes.
And there was, once again, any objection to these expenses?
Never.
Okay, I want to move on, Ms. Hodges, I want to go to your American Express card, and I want to go to specifically 2020, Exhibit 25.
Okay.
And just so the court's aware, Judge, I am skipping over a majority of these exhibits, which are exhibits that took place during the marriage. I'm focusing solely on the time post-divorce filing.
Okay, I'm there. It's statement, closing date is 1/29/20.
Okay. And I want you to see that there's several pink highlights within this document as well, which is your American Express statement. Is that right?
Yes, sir.
And can you tell the court what, if any, a majority of these expenses are related to, specifically referring to page 3?
Page 3.
It's page 3 of 67. It may not be page 3 of the statement.
Again, those are medical expenses for justice.
There's one highlighted on January 8th of 2020, People Finders. Can you tell the court what that is?
It would have been research for someone.
What kind of research?
I have friends call me, my friend that runs the store, for instance, and she'll say, this tag is, someone's parked out in front. And so, they would park there for 4 hours and she has, reserved parking. She'll ask me to run it, that type of stuff.
Did you do any of this type of research for your husband and his business?
All the time.
What did he have you do, for example?
He had me locate people that he was trying to subpoena.
And would you use
Or
this
serve, I
type
should
of,
say. Sorry, serve, not subpoena.
and would you use this type of software, the peoplesfinder.com, to assist in that?
Absolutely.
And let's move on to page 4 of 67 in your American Express account ending in 63000.
Okay.
What is Heights Floral Shop?
It's a flower shop.
And why is there a purchase at Heights Floral Shop for January 17th of 2020?
I sent flowers to one of my best friends for her birthday. I don't give her a gift. It's the only thing we do every year is on each other's birthday.
Okay. And then the following transaction on January 22nd of 2020, what is the nightsky.io?
It was actually a birthday gift or a Valentine's Day gift for Mr. Hodges for that year.
It was a gift from you to him?
Yeah, that I had
Okay.
ordered.
And what was it that you ordered?
It was a picture of the stars on the constellation on the night that he was born.
And then moving down onto January 28th, it looks like STI Inc.
Tell you
Two
the truth,
purchases.
yeah, I don't remember what that is.
Okay. And then if we move on into the additional statements, and I'm going down to page 13 of 67 now, Ms. Hodges.
Okay, all right, let me get that. Okay, I'm there.
All right, you see on April 25th of 2020, therapy pet. I'm assuming, is that for justice?
Right, she's a certified therapy dog.
And then the following transaction on the 28th of April 2020, what is that?
It's the premium for her pet insurance.
Okay. And then moving down to May 15th of 2020, Ring Multicam Yearly. Can you tell the court what that is?
What page are you on? I'm sorry.
I'm still on page 13 of 67.
Okay. It's the yearly service and warranty contract for Ring cameras.
And what is Ring that you have?
They are security cameras inside and out. And that's the fee for the storage of the video and then any service problems or replacement. And
When did you
support.
obtain a Ring security system?
She could get the video, but she's paying for storage for it.
I can't, I know
Do
it
you
was
remember?
after Mary Molina moved in because her car was broken into. We didn't have the cameras. I want to say it was in the fall of 2019.
And who paid for that system?
Mr. Hodges, it was a gift.
He purchased the system for you?
Yes,
And the multi-cam yearly subscription that's on your American Express statement that I just asked you about, which is marked as a transaction on May 15th of 2020, in the amount of $107.25. That's the yearly subscription for that Ring security system?
yes, sir.
Okay. And are you aware of whether Mr. Hodges was aware of this subscription when you were married?
Yes,
and cohabitating in the same household? When y'all were cohabitating, living together prior to the filing of this divorce, was Mr. Hodges, to your knowledge, aware that there was a yearly subscription for the Ring camera?
Yes,
And did he ever inform you that he was opposed or objected to you paying for that?
no,
And did that benefit Mr. Hodges as well?
yes.
And moving further down. Can you tell me what Zulily is?
Zulily is a service online. It's similar to Amazon, but on a much tinier scale.
And if you notice in their reimbursement claims, they're alleging that they should be reimbursed for some Zulily purchases. Can you tell the court what you purchased through Zulily?
Well, depending on the year that they chose, like all the Christmas gifts, or a good majority of them, for his children and his daughter's mother and his mother when she was alive, I purchased in Zulily throughout the year. And then because they have such good deals, and I would just accumulate them.
So a majority of what you purchased through Zulily was for gifts for his family?
Yes.
And then on page 42 of 67, I'll give you an opportunity to get there, Ms. Hodges.
Okay. Okay, I'm there.
There's a purchase on 9/23 of 20 at ancestry.com. Can you tell the court what that is?
Yeah, I was just doing some, let's see, am I in the right place? Yeah, that's the annual membership for Ancestry. I was just doing Family Tree.
Do you believe that's something that warrants a reimbursement to Mr. Hodges?
No.
And looking through the remainder of the statements, Ms. Hodges, do you see any reimbursement claims that you believe warrant a reimbursement by you to Mr. Hodges?
No,
Why not?
because the majority are expenses for justice and or medical treatment or food and supplies, dog-related expenses, basically. And those are expenses that we had during our whole marriage, were dog-related expenses, basically for justice and all the other fosters.
And you've heard Ms. Phoenix's opening statement in which she alleges that you are not responsible with your spending and you've maxed out your credit cards. Do you believe these credit card transactions evidence frivolous spending?
No,
And why is that?
because they're necessary expenses to keep justice, somewhat healthy and in a comfortable quality of life.
Well, what other types of expenses are you incurring through your credit cards that are important for this court to be aware of?
Household expenses, expenses for my car, pharmacy, medication.
Anything abnormal or out of the norm?
No, OnStar for my vehicle, in case of an accident or a theft.
Are there any expenses that you started incurring after the divorce was filed that you would not have been incurring when you were married and cohabitating with Mr. Hodges?
Not one.
So all the transactions that we're referring to after you filed for divorce, were these transactions that you were incurring while Mr. Hodges was residing with you in the household?
Yes.
Moving on to, it appears to be Exhibit R27, Ms. Hodges. That is your City Simplicity card
Okay.
ending in 4036.
Yeah, it's taking it a second. Just. Okay.
And I want you to go through this statement beginning on page 2 of 32. and you'll see pink highlighted transactions. And I want you to tell the court, starting with page 2, going down, what these highlighted transactions are.
They're all vet expenses for Justice at the Cancer Center.
And going down to page 6 of 32.
They're all justice-related expenses. One is the Cancer Center. The other 2 are the special vitamins and stuff she takes. And then the other one would be food and treats.
So if you have an opportunity to look at every single highlighted pink highlighted transaction within this credit card statement, can you tell the court what it is related to?
Hold on, I'm just scanning them real quick. They're all justice-related bills.
And I want you to look at the second to last page, which is page 30 of 32.
Okay, one second. Oh, the Love Pop.
Can you explain to the court what that is?
Yeah, it was a card to my mother for her birthday.
So nothing related to anything inappropriate.
No. Mm-mm.
And I want to move down to the Wells Fargo account ending in 5082. And let me locate the month that I want. Let's start
what
with
exhibit? What exhibit is it?
Exhibit R30, Ms. Hodges.
Okay. Okay, starts with a
Okay.
11020.
It starts with month statement 12/12/2019 to 1/10/2020.
Yes.
And
I
this
got
is
it.
for card number ending 5082. Are you on the right statement, ma'am?
Yes.
Okay. And you see, once again, pink highlighted transactions in which Mr. Hodges is seeking reimbursement for. I want you to tell the court what's on page 1. What are these transactions for?
The first transaction is for Justice again at the Cancer Center. The next one is for Choice Home Warranty, which is a warranty that's I pay monthly on the house that I've had the entire time I've had the house. And then some others were some investigative sites.
Justin has been insurance in person.
The truthfinder.com and Spokio Search are all investigative sites.
Yes, sir.
What are they typically used for?
You can locate license addresses, some reverse searches for address, tag numbers, various things, phone numbers.
And moving down to the next month's statement on page 5 of 58, there's additional highlighted transactions. Can you tell the court what those are related to?
Sure, just a second. Again, those are justice expenses.
So nothing abnormal as of now,
No.
correct?
No.
And then scanning through the statements, if you have an opportunity to, Ms. Hodges, can you tell the court if any of these highlighted transactions that Mr. Hodges is seeking reimbursement for are anything not related to justice or your home warranty or the services that you've just described for investigative services?
No, just in doing a quick scan, that's all they all are. The majority are justice, and then a small portion are, of course, the home warranty once a month, and then a small portion of the other items, and that's it.
And were these, once again, expenses that you were incurring while Mr. Hodges was residing with you in the household prior to you filing for divorce?
Yes, the entire time.
Was Mr. Hodges aware of these expenses?
Yes.
Did Mr. Hodges at any point in time tell you he's not in agreement with you spending money on these items?
No, never.
Do you believe that Mr. Hodges should be entitled to a reimbursement claim for these expenses?
No,
Why not?
because he received the benefit of justice while we were cohabitating together, as you say. The home warranty benefited him also. We had to use it on a refrigerator that was clearly a lemon. It needed about 20 service calls. And he never objected to any spending. In fact, all the vet.
Objection to the marriage judge.
Thing.
Ms. Hodges, you were going to make a statement regarding vet expenses. Can you tell the court what you were going to state in regards to vet expenses concerning
Yes.
Mr. Hodges?
In fact, I discussed all the vet bills always with him, especially on many of the vets, you get a pre-estimate. He never objected to anything for her, never.
So Mr. Hodges was aware of the expense before it was incurred?
In most cases.
All right, let's move on to the Wells Fargo account, which is your recent, I guess the most recent credit card statement for account ending 5082. That's Exhibit 31. Just let me know when you're there, ma'am.
Okay. Okay, I'm there.
And I'm going to start on page 1 of 31. And you see, once again, pink highlighted transactions in which Mr. Hodges is seeking reimbursement for. Can you tell the court what these are?
Yes, the first one is the home warranty. The next one is an investigative site. And then the PPG is a gallon of paint
What'd you use the paint for?
to paint the bedroom back to red as it was.
Do you believe that warrants a reimbursement claim for Mr. Hodges?
No,
Did that in any way increase the value of your home?
no.
And scanning through the additional highlights throughout all of these transactions in Exhibit R31, can you tell the court if there are any highlighted transactions other than for the warranty or for truthfinder.com?
I'm scanning real quick. No, I don't see any, just in doing a quick scan.
And I'm going to move on to, let me confirm the date on it. Exhibit 33. See if that's the right year. No, that's going before marriage. It should be Exhibit 34 then. I apologize.
Okay. Okay.
So you have, in addition to the prior credit card, you have a Wells Fargo Visa ending in 3647. Is that right, Ms. Hodges?
Yes.
Okay. And can you tell, are you able to see the highlighted transactions on these credit card statements?
Yes.
Can you tell the court, after you review them briefly, what the highlighted transactions are related to?
All I see just in a brief scan is dog-related expenses and Truth Finder.
And are any of these transactions, in your opinion, transactions that warrant a reimbursement claim by Mr. Hodges?
No, sir,
Why not?
because these are the same expenses that were incurred for justice all during our marriage. And then the investigative stuff, like I said, in the past, I've always helped him look up whatever he needed to help serve papers.
Are these truthfinder.com, are these a subscription service or do you pay per use?
You pay per use. I don't have a subscription.
Okay. So can you tell the court why you would be using the service if Mr. Hodges was no longer in the residence and y'all were separated at the time some of these transactions were incurred?
Because he produced a phone bill. Truth Finder specifically is a good site to use for reverse phone search.
And so what were you trying to accomplish with the truth finder at
I
this
was,
time?
I was looking at all the women he was communicating with.
And were you successful in determining that?
Yes.
And what were you able to determine through Truth Finder regarding Mr. Hodges' phone calls?
That he's had multiple women contacts, including Natasha Coe, all after 10 o'clock at night, up until the middle of the night.
And to your knowledge, what is Mr. Hodges and Natasha Coe's relationship?
I believe it's friends with benefits at the very least.
Why would you say that?
Because anything that's happening at midnight and 1 o'clock for 30, 40, 50 minutes is not a business relationship almost on a daily basis.
Can you elaborate for the court what you mean happening on a daily basis, 30 to 40 minutes after midnight? Can you be specific in what you're saying?
Yes, that they would call each other at midnight, 1 a.m., talk for 30, 40 minutes almost on a daily basis. She would call him or he would call her every night at 10 o'clock. That's, the majority of the calls. There are other calls.
When you were residing with Mr. Hodges, would that be something that would happen on a frequent basis, that he would be on the phone or have to communicate about work-related matters at 10 or later in the evening?
No, in fact, his rule, even for his
Objection
family.
after no.
Oh, I'm sorry.
Did Mr. Hodges have a rule, ma'am?
Yes, Mr. Hodges had a rule that he took no
And what-
phone calls, not even from his family after 9 o'clock.
So to your knowledge, when did these late night phone calls begin?
The late night phone calls with Natasha started about a month before he moved out.
And so these Truth Finder transactions, your testimony is that you use them to do research on the documents provided by Mr. Hodges, specifically his phone records.
Yep.
So are these expenses incurred in relation to this lawsuit?
Yes, absolutely.
And then I'm going to move on to now R35, Ms. Hodges.
Okay. Okay, I'm there.
You see on page 1, there's one highlighted reimbursement transaction that Mr. Hodges is seeking reimbursement for, which is what appears a payment to Mike Ball Irrigation. Can you tell the court what that is for?
Yes, the landscaper accidentally cut through one of the irrigation lines and it was leaking, so I had to have it repaired.
Did this in any way improve the value of the residence?
No.
It appears that this was your testimony, it sounds like it was a maintenance issue.
Right.
Do you believe Mr. Hodges should be reimbursed for this expense that you've incurred?
No.
You currently have 2 retirement accounts. Is that right, Ms. Hodges?
I have a pension. Yes.
Can you tell the court what the accounts are?
One is a pension fund and one is a deferred comp.
Okay. And you've included those within your sworn inventory and appraisement, have you not?
Yes.
And in addition, Mr. Hodges has listed them in his sworn inventory and appraisement. Are you aware of that?
Yes, because of what you provided.
And currently, each account has a certain balance. Is that right?
Mm-hmm.
And I'm going to have you refer to our exhibit, which is Petitioner's exhibit number 3, which is your, actually it's Petitioner's exhibit 2, which is your sworn inventory and
Oh,
appraisal.
petitioner. I'm sorry. I have to go to the other.
I'm sorry, I'm moving you back and forth. I'm just trying
Okay.
to get.
What was the number again? I'm sorry.
It was Petitioner's exhibit 2, which is our inventory with all the attached exhibits
Okay,
to your.
let me go to the top.
Right.
Okay.
And so listed in your inventory and appraisement, you have a HMEPS account. Can you tell the court what that is?
That's the pension account.
And it currently has a value you've listed in your inventory of community value, $34,810, but a net value of $43,347.
Yes.
Why is there that difference in valuation?
Because it starts in 2008. So from 2008 till 2011 would not be included in the marriage.
Okay, so is there a separate property amount of that pension that should not be considered in the division of this estate?
Yes,
All right. And the amount you've listed is $8,537. Is that the correct amount that you believe is your separate property?
yes.
And how is that number calculated?
It's the total balance, the 43,347.55 minus 2008, 9, 10, and 11.
Okay. And the sub exhibit within your inventory, which is your sub exhibit 6, INA exhibit 6 that's listed in that inventory folder. Can you open that, Ms. Hodges?
Exhibits.
This is it's your INA exhibit. It's the document attached to your INA. So if you go into your exhibit number 2.
I have INA exhibit 6, but it's
That's
the
correct.
HEMS.
That's the one I'm referring to.
Okay.
If you'll open that
Okay.
and refer down to page 2. And the calculation that you just testified to the court, did you obtain those numbers from this valuation report for years prior to marriage?
Yes.
And so you've added up 2008, 2009, 2010, and 2011 and totaled that amount to be the amount listed in your inventory and appraisement as the separate property value?
Yes.
Okay. And you're asking the court to confirm that as your separate property?
Yes.
And in addition to that HMMPS account, you have it appears a deferred compensation plan with the city of Houston. Is that right, Ms. Hodges?
Yes.
And can you tell the court what your community value of that account is?
Hold on, let me open that. Hold on. It is $13,910.64.
Is that the community value or the net value?
That would be the community value.
Okay, I'm gonna ask you to refer to your inventory and appraisement, Ms. Hodges.
Okay. Hold on.
I'm having you bounce back and forth, but I need to clear.
Yeah, it says net value. I'm on it. I'm on
Okay.
page.
So this
2.
city of Houston deferred compensation plan, did you have this plan prior to your marriage to Mr. Hodges?
Yes.
So would a portion of this plan be acquired prior to marriage?
Actually, no.
That was cool.
So this was all acquired during your marriage to Mr. Hodges?
Yes.
If you refer to page 2 of exhibit number 7, the INA exhibit 7, that's your Empower Retirement City of Houston Deferred Compensation Plan.
Yes.
Okay, you see beginning balance as of 11 November 2011. You see that on page 2? Can you tell the court what that amount is?
What the amount is $13,910.64.
No, ma'am, I think we're looking at the wrong thing.
I'm on exhibit 7.
Yes, I'm asking you to look at exhibit 7, but page 2 of exhibit 7.
Oh, okay. Okay, I'm on page 2.
Okay, there was an amount in this account prior to your marriage. Is that correct or is that incorrect?
Incorrect.
So this $3,154.02 listed as beginning balance as of November 11th, 2011 was not acquired before marriage?
Yes, I'm sorry. I'm confused about what you're asking.
I'm sorry. Okay. So this City of Houston deferred compensation plan was something that was in existence before you married Mr. Hodges. Is that right?
Yes.
Okay. So it started accumulating funds within it before you married Mr. Hodges. Is that right?
Yes,
Okay. So at the time of your marriage to Mr. Hodges, is it correct that you had $3,154.02 in this account?
yes,
Are you asking this court to confirm that amount as your separate property
yes,
and the remainder balance, which you have listed in your inventory of $10,756, you're in agreement as community assets
yes,
and subject to a just and right division? Is that right, Ms. Hodges?
yes,
In addition to these two retirement accounts, are there any vehicles owned by the community estate?
yes.
What vehicle do you currently drive?
I drive a 2016 Yukon.
And in your inventory and appraisement, you have it listed at asset value of approximately $20,840. Is that right?
Yes,
However, is there a loan associated with this vehicle?
yes.
And who is that loan payable to?
Allied Bank.
And in your inventory, can you tell the court what the current amount of the loan balance is?
Hold on. $6,748.
And so does that make the net value or the community value of this vehicle $14,092, ma'am?
Yes,
Are you asking this court to award you your vehicle in your possession?
yes.
In addition to this vehicle, what other vehicles are within the community estate?
There's a Ford F-150 King Ranch and a 2013 Toyota Prius.
And who currently maintains possession of those two vehicles?
The respondent.
And listed in your inventory, you've listed the asset value of the pickup truck, the 2015 F-150 at $33,838. Is that right?
Yes,
And how did you determine the value of that truck?
minus the loan amount.
Okay. And is that based on a CarMax, Carfax, Kelly Blue Book? How did you determine the value?
Carfax.
Okay. And the current loan associated with the vehicle you have listed at $23,000. Is that right?
Yes,
And so you're saying the community value of this truck is $10,838. Is that right?
yes,
And moving on to the Toyota Prius that you testified is currently in the possession of Mr. Hodges, you've stated it has an asset value of $12,955. Is that right?
yes.
How did you determine the value of that vehicle?
Carfax.
And is there a note associated with that vehicle as well?
Yes,
What's the balance of that note, if you know?
9,000.
So the community value of that vehicle is $3,955.
Yes,
Are you asking that these two vehicles be awarded to Mr. Hodges?
yes,
In addition to the vehicles that we've just addressed, were there any settlement claims and payouts that you're aware of that occurred during the marriage?
yes.
What are you aware of regarding any settlement payouts?
Mr. Hodges had an accident in which he received an insurance or a lawsuit settlement.
And do you know what the amount of that settlement was?
It was 48,000 and some change. I don't recall. I believe it was like 48,934.
Were there any additional settlements that were paid out to Mr. Hodges during your marriage?
Yes, he also had a Prius that he received a settlement for $894, I believe.
And was there any other settlement?
Just, I mean, from the truck, he received, in regards to the accident, he received a 15,000. I don't remember the change amount either, but 15,000 plus for the settlement on the truck.
So there were three settlements to your knowledge. One, you stated in approximately 48,000 and change, another one related to the pickup truck and approximately 15,000, and another settlement totally related to the Prius and $894, you stated?
Yes, sir.
Okay. So in total, the approximate payouts to Mr. Hodges on these settlement claims is approximately a little over $63,000. Is that your understanding?
Yes, sir.
And you're asking the court to order a reimbursement claim for these insurance payouts?
Yes,
Why are you asking for a reimbursement claim related to the insurance payouts?
because vehicles were all acquired during the marriage and the payout was during the marriage.
Who were the payouts issued to?
Well, originally the payout for the truck was issued in a check to both of us. And then he had the insurance company stop payment and direct payment to his account. The other accident settlement
Objection.
would,
No responsive.
Overruled. You may continue, ma'am. The other accident you said?
the other accident was for the Prius. And there was a loan value on it. So he had that direct deposited to his account too of $894.
I'm going to refer you, Ms. Hodges, to what's been previously marked and admitted into evidence, which is Petitioner's Exhibit number 26.
Okay.
That is the lawsuit settlement related to Mr. Hodges versus Mr. Miguel Pacheco.
Hold up. I'm looking for 26. Mhm. I'm sorry, I don't see 26. Let me see.
I think you may be in the inventory exhibits. You have to get out.
Oh, okay. Here we go. Oh, okay. Hold on. Okay, I'm there now, sir.
Okay. Can you tell the court what that document is, if you know?
It's a settlement statement from the law office of Hale and Manicum,
And how much was payable to Mr. Hodges?
$46,984.
Do you know where those proceeds went after they were distributed to Mr. Hodges?
No,
Do you believe that Mr. Hodges wasted those community funds?
yes,
You have a claim for fraud on the community. Is that correct, Ms. Hodges, within your petition for divorce?
yes,
Has Mr. Hodges ever provided to you any documentation evidencing where these funds went after he received them?
no,
Do you know if they were deposited into his bank account?
yes,
But once in his bank account, you have no knowledge where the funds went?
no.
I'm going to move on to exhibit number 27. When you're there, let me know.
Okay,
And can you tell the court what this document is?
it's a total loss statement from USAA.
Okay.
Oh,
And is this what you were referencing in regards to Mr. Hodges receiving $890 something for the Toyota Prius?
yes,
And are you aware of where these funds went after they were distributed to Mr. Hodges?
no,
And then I'm going to move on to exhibit 28. Can you tell the court what this document is?
it's a total loss statement from USAA.
And this is what was distributed to Mr. Hodges, where it states vehicle's actual cash value, $15,184.
Yes,
Do you know what Mr. Hodges did with those proceeds?
no,
Did he acquire a new pickup truck at any point in time after receiving these proceeds? Do you know?
yes,
Do you know if he put any money down on that truck or not?
yes,
How much did he put down on that truck?
1,500.
Okay. And I'm going to reference you to what was previously marked and admitted into evidence, Exhibit 29. It's Petitioner's Exhibit 29.
Okay, I'm there.
Okay. And what is this document, ma'am?
It's the check that USAA made out to both of us for the loss of the truck.
And you testified earlier you never received that?
Yes, I received the check, but I didn't receive the proceeds.
What happened with the check?
USAA told me that Mr. Hodges stopped.
Objection, hearsay.
Same.
What happened with the check, Ms. Hodges? Not what someone told you, just what happened.
They stopped payment on the check and
Okay.
Mr. Hodges.
Objection, after they stop payment.
Same.
And then what happened with the proceeds in the amount of $15,683.73? Where did they go?
Mr. Hodges had them direct deposited into his account.
And do you know what Mr. Hodges did with those proceeds?
No,
I'm going to reference you to exhibit number 30.
Okay.
Let me know when you're there. All right.
I'm there.
This is the agreement to purchase the new vehicle that you testified Mr. Hodges purchased after the accident. Is that right?
Yes,
And less cash with order on the right side. Is that the 1,500 you're referencing that was used to put down for this vehicle?
yes,
Okay. And so this is the vehicle Mr. Hodges currently has in his possession. Is that right?
to the best of my knowledge, yes.
Okay. And I'm going to reference you to exhibit number 35, Ms. Hodges. This is Wells Fargo account ending 0002, which is a savings account in the name of Mr. Hodges as well as Ms. Powell.
Yes, I'm here.
Can you tell the court if you know what this is?
Yes,
What is it?
he is the representative for his sister on her Social Security disability payment for mental health.
So are the Social Security payments directed to Mr. Hodges?
They're direct deposit into this account and he's supposed to manage them and
Okay.
report back to the Social Security Administration.
Do you know whether he does that or not?
He does not.
Do you know where these funds go?
No,
But these are not Social Security benefits Mr. Hodges is entitled to. These are Social Security benefits he's entitled to on behalf of his disabled sister. Is that right?
correct.
Okay. Sorry, Judge, I'm just trying to go through the exhibits.
No problem. You're going through them quickly.
They're loading a little slower than I wanted. All right, Ms. Hodges, I'm going to reference you to what is previously marked as Petitioner's 25. And this has not been stipulated to by Ms. Phoenix.
Okay, I'm there.
And I want you to tell the court, is this a document prepared by you in anticipation of this litigation?
Yes,
Is this a document that you prepared based on your actual knowledge of payments to the IRS?
yes,
Is this basically a shorthand rendition of what payments you've made to the IRS throughout
Yes.
your marriage?
yes.
Your Honor, I would offer this as Petitioner's Exhibit 25.
All right, Ms. Phoenix, any objection to P25?
Yes, Judge, it's hearsay.
So is this I heard it was
This
a
is-
shorthand rendition, hold on, it's a shorthand rendition of what her testimony would be, but is this actually a report from the IRS or is this a report that Ms. Hodges created?
This is a report that Ms. Hodges created, Your Honor.
All right, the objection to P25 is overruled. P25 is admitted.
Ms. Hodges, I would ask you to open Exhibit 25, Petitioner's Exhibit 25.
I have it open.
All right. So throughout your marriage, can you tell the court how predominantly you and Mr. Hodges handled the payment of taxes to the IRS?
I paid them.
And prior to your marriage to Mr. Hodges, are you aware of any IRS top tax obligations Mr. Hodges brought into the marriage?
Yes.
What are you aware of, ma'am?
Mr. Hodges didn't file income tax from 2000, I believe it was 2000 or 2002 up until 2010. And so he owed $55,000 to the IRS for taxes, interest, and penalty.
And did you assist Mr. Hodges in any way in negotiating this settlement to the IRS?
Yes.
What did you do?
I told him I wouldn't marry him unless he got his tax stuff straight. And then I found him a certified tax attorney because his bank account was already being levied by the IRS for the debt.
And so to your knowledge, was a payment plan worked out between Mr. Hodges and the IRS?
Yes.
What, to your knowledge, was the payment plan worked out?
They dropped the levy and he was to pay $471 a month till the balance was paid.
When did the $471 monthly payment begin, to your knowledge?
Shortly after we were married. So let me say beginning of 2012.
So after your marriage to Mr. Hodges, is it your testimony that he paid $471 a month to the IRS for income taxes that were incurred prior to your marriage?
Yes.
Are you asking for Mr. Hodges to reimburse the community estate the total amount that he paid to the IRS, which you have listed in your document, Petitioner's Exhibit 25, $53,223?
Yes, sir.
And in addition to those taxes that Mr. Hodges was paying out, which were incurred prior to his marriage, did he pay other taxes throughout the marriage?
The only taxes, well, let me qualify, from the time that he was self-employed.
Non-responsive, Judge. Objection.
Overall, I think she's trying to answer it. Ma'am, you may continue.
From the time that he was self-employed in 2015 and on, the only income tax he paid, regardless of his income, was what was taken out of his military retirement, which amounted to about $2,000 a year. He paid no other taxes, even when his income reached six figures.
Who paid the taxes if Mr. Hodges did not?
I did. I borrowed, oh, go ahead.
And what monies did you use to pay these taxes?
I borrowed money out of my deferred comp.
And that's how you were able to pay the taxes to the
Yes.
IRS?
Yes.
I'm going to reference you to the IRS letter regarding Petitioner Exhibit 41, stated Dan Castillo IRS letter.
Okay, I'm there.
Can you tell the court what this letter is?
It's an email from Daniel Castillo, who was the tax attorney that I found, to the respondent about the levy and the monthly installment agreement with the IRS.
And can you tell the court why this letter is relevant to this divorce matter today?
It shows that the debt existed prior to the marriage and that he, all throughout our marriage, was paying a previous debt that I had nothing to do with out of community funds. The only reason that the IRS chose to use.
Objection, non-responsive.
And
Oh, can I continue?
I didn't hear the judge's ruling. I didn't.
Oh, I'm
Oh,
sorry.
me either.
I'm sorry. I said sustained. Sorry.
Oh, okay.
Thank you, Judge.
I said it. My mic didn't pick it up. Sorry.
Ms. Hodges, I'm going to reference you to Petitioner's Exhibit 4, which is IRS transcripts.
Four.
I'm sorry, what was the exhibit number?
4, Your Honor, number 4.
Something like some confusion. That's what I talked to her about. This is.
And Ms. Hodges, are these is this a transcript from the IRS which evidences the $471 payment to the IRS?
Yes,
And once again, does this confirm that Mr. Hodges was paying tax obligations incurred prior to your marriage to the
Yes.
IRS?
yes,
And these payments were all made while you and Mr. Hodges were residing together and married?
yes,
And once again, are you asking for a reimbursement to the community state of every dollar he paid to the IRS during your marriage?
yes,
For specifically the taxes he incurred prior to marriage, right?
right,
You're not asking for reimbursement for any taxes incurred during your marriage.
no, sir.
Do you believe Mr. Hodges to be an honest man?
No,
Why would you say no to that answer, ma'am?
through the course of this divorce, almost everything he told me was a lie through the bank statements and other information that has been provided through discovery. One of the things he told me, the lawsuit settlement was 40,000. It was not. I mean, simple things like that.
Do you know if Mr. Hodges has graduated from any college or university?
He has not, nor did he, oh, no.
How do you know that?
Because he claimed that he went to college during our marriage. He did not.
Did Mr. Hodges at any point in time request a phony transcript, to your knowledge?
Yes, he ordered one.
I'm going to reference you to what's been previously marked as Petitioner's Exhibit number 40, which has already been admitted into evidence.
40, okay. I have it open.
Can you go down to the last page, page 4, and tell the court what that is stating for Mr. Hodges?
Can you send me a sample transcript from Mountain State University for an undergraduate?
Objection, Judge, objection, that's hearsay. And they've not proven that that came from Mr. Hodges, excuse me.
So 40 is already in evidence.
Oh, I'm sorry, Judge.
About the,
I thought it wasn't.
okay.
Let me look.
Let me make sure. I show that's in.
That one.
Yeah, Judge, remember that was not objected to when we stipulated.
Yeah, no, I show my notes.
Okay, I'm sorry, Judge. I thought I objected to that one. But that's, if I didn't, then I didn't.
Yeah, I show Petitioner's 40s in evidence and there was no objection. So you may
Sorry,
continue.
Judge.
And Ms. Hodges, going back to page 1, after you see the request from Mr. Hodges, do you see the response?
Yes.
On page 1, and what was the response, ma'am?
It says, Gary, this email is to confirm your purchase of a Mountain State University phony transcript degree for degree in, or phony transcript for degree in business for a purchase of $450. The phony transcript will be sent out in 7 to 10 days. Thanks for your order.
To your knowledge, Ms. Hodges, why would Mr. Hodges need a phony transcript?
Objection, Judge, calls for speculation.
Sustained.
Well, Ms. Hodges, in your opinion, why would Mr. Hodges need a phony transcript?
Objection calls for speculation. It's not relevant.
Sustained.
Do you know why Mr. Hodges requested phony transcript?
Yes.
Objection, not relevant.
Overruled. She said yes.
Objection, speculation.
She said yes, that she knows the reason. So objections overruled.
Okay.
What is the reason, Ms. Hodges?
He was applying for a job with the city of Houston and the waste department, and they required a degree, which he didn't have.
So does this confirm your prior testimony in regards to Mr. Hodges not being an honest man?
Yes.
In your sworn inventory and appraisement, Ms. Hodges, you've asked for a significant amount of reimbursement to the community estate. Have you not?
Yes. Yes.
That amount is in the amount of $468,625. It's a significant amount of money. Can you
Yes.
tell the court why you believe that amount of money is a valid reimbursement amount for this community estate?
Because at that particular balance is only the money that was spent by Mr. Hodges from the day he moved out. And so it was a waste of assets on dates, dating sites, other unnecessary expenses, and it violated the temporary restraining order that was in place from 2/13/20 on. Large amounts of cash were withdrawn. I mean, like over 50,000. Mr. Hodges never had a spending pattern like that prior to moving out, and we have all the bank statements to prove that. And so it was just a waste of assets. I wasn't allowed to do that. My only expense was.
Objection to the narrative, Judge.
Sustain the last part.
Did you ask that I document his spending early on in this divorce and acknowledge it for his current attorney?
Yes.
I'm going to ask that you reference Petitioner's Exhibit number 21, Ms. Hodges.
Okay. Okay, I have it open.
And is this a letter that I sent to opposing counsel back in May of 2020 addressing the excessive expenditures that Mr. Hodges was conducting at the time?
Yes.
And I want you to reference within the letter, specifically account ending in 9908. And these are some of the expenditures that Mr. Hodges was incurring. Is that to your knowledge?
Yes.
What were some of these that were very concerning to you?
The large cash withdrawals, the dating sites, that's just the spending in general. He has, in just a short period of time.
Objection, not responsive after she gave her list.
From the date that Mr. Hodges, around or about the time Mr. Hodges left the residence through March of 2020, do you know an approximate amount of ATM withdrawals that Mr. Hodges incurred?
Let's see. $4,700. Well, 57, about $6,000.
Okay.
According to this letter. Mm-hmm.
And that was only from that account ending in 9908, is that right?
Yes.
So this letter states on page 2, these are expenditures only for accounts stated above. Please note that the ATM withdrawals alone since January through March are around $8,000. And it's evident that Mr. Hodges is spending money on dating as he has purchased memberships in several dating apps such as Zeus and Elite Singles. And you were still married to Mr. Hodges at this time. Is that right, Ms. Hodges?
Yes.
Do you believe that this is an appropriate way to expend community resources and funds?
Absolutely not.
Is this one of the reasons you're asking for reimbursement?
Yes.
Because of expenditures on dating apps and possibly going out to dinner and with other women?
Yes.
And going on to Mr. Hodges' personal account ending in 3027, we've also included potential concerning expenditures, and those are listed within this letter, are they not?
Yes.
And so going down to the bottom of the letter, ma'am, it's been presented that between the business and the two personal accounts of Mr. Hodges, and I'm reading the letter, the ATM and cash withdrawals made by Mr. Hodges since January total over $14,000, not including the additional unnecessary expenditures at restaurants and on gifts. Is that right?
Yes.
And so I'm going to reference you, Ms. Hodges, after this letter to the bank statements of Mr. Hodges, which we have included in our inventory, which are in our exhibit list, starting with petitioner's exhibit number 5.
Okay.
Since you're transitioning and we're about to be going through, I imagine, quite a few bank records, why don't we go ahead and take our afternoon break, give the witnesses a chance to hit the restroom if they need to. We'll resume at 3:15. We're going to go off the
Thank
record.
you, Your Honor.
All right, we're back on the record in the Hodges matter. Mr. Zane, you may proceed.
Thank you, Judge. Ms. Hodges, I was asking you to look at, prior to us taking a break, Petitioner's Exhibit number 5, which has been previously offered and admitted into evidence.
Okay, I have it open, sir.
Okay, and tell the court what that exhibit is.
It's a banking statement for AAA Justice for the month of February 2020.
Okay. And I think to simplify this and assist with the court, but let me just start with this. You've got a reimbursement claim because you're alleging that your husband has wasted community funds. On top of that, we pled fraud on the community, meaning that he's wasted money and has provided no explanation for it. Is that correct?
Correct.
So going through this bank statement, I want to go through this one real quick with you. Can you tell the court what concerning transactions there are specifically in this bank statement?
Do you want me to address the checks first or?
No, let's go with the checks. Yes. What concerns do you have related to the checks that were expended in this account?
We were never provided any copies of the checks, so I don't know who any of this was written to. So
And did we file formal discovery requests?
yes,
Did we go to court several times on motions to compel, Ms. Hodges?
yes,
And as of today's date, do we have any copies of any of these checks written in this account?
no,
And in addition to that, ma'am, were there 18 withdrawals out of this account?
yes.
Judge, I'm going to object to leading by Mr. Zane.
All right. What other concerning transactions do you have or are there within this bank account statement?
There's the large cash withdrawals and the amounts being spent at restaurants, edible arrangements, all types of expensive meals, clearly for 2 people, not 1.
Prior to Mr. Hodges leaving the residence, to your knowledge, did Mr. Hodges expend money like he is within this current statement?
Absolutely not.
And going on to, you stated that there were 18 withdrawals. I want to reference you to February 5th of this year in which there's an 18 withdrawal. Can you tell the court what amount of an 18 withdrawal there was?
$1,500.
And to your knowledge, has Mr. Hodges explained that withdrawal?
No.
Was there a deposition conducted of Mr. Hodges very recently, ma'am?
Yes.
And to your knowledge, was Mr. Hodges asked about these 18 withdrawals?
Yes.
To your knowledge, what was Mr. Hodges' response to the 18 withdrawals?
He didn't know or he couldn't remember.
And in this month alone, there were $1,500 in 18 withdrawals. Is that correct?
February, March, just security payment.
It's hard to hear when someone else keeps talking.
Yeah, we're able to pick up. Mr. Hodges, you don't want us hearing your conversation with your lawyer, so maybe you just give him a legal pad. It might help.
Oh, I'm sorry, Judge. I didn't know you could hear him. Sorry about that. I'll tell him to tone it down.
Okay, so he also, in addition to the 1,500, he also would go and make.
Objection, Judge, to non-responsive. There's not a question to her.
Well, he asked if there was other ATM deposits other than the 1,500, but I don't think she's answering that question. So sustained.
What other expenses other than the 1,500, Ms. Hodges, are concerning to you that would relate to a reimbursement claim?
In addition to the items I've already named, when he would go purchase something, he would also take additional cash, like $30 here.
Objection, Judge, it's non-responsive.
Judge, I believe she's answering the question.
Well, the objection is sustained.
Okay. Were there any cash back transactions that concern you, Ms. Hodges?
Yes.
What are they, ma'am?
Well, there's after the 1,500 that we spoke of, here's another 60, another 30, another 60.
Okay. And there's a transaction for on February 4th for Lawrence Fragrances. Do you see that, ma'am?
February 4th. Yes.
Do you know what that would be for?
I'm assuming fragrances just by the name, but I don't know that for a fact.
When you were married to Mr. Hodges and y'all were cohabitating together, were you aware that he was making any transactions and purchases at Lawrence Fragrances?
No.
Then there's a transaction on February 11th for Ann's Fine Gifts. Do you know what that would be for?
I do not.
And you previously testified to the edible arrangements transaction on February 18th.
Yes.
Right? And that was one that was concerning to you, correct?
Yes.
Okay. Have you gone through Mr. Hodges' AAA Justice account ending in 9908 statements after this month?
Yes.
Have we received, to your knowledge, Ms. Hodges, all Mr. Hodges' bank statements from the time of divorce up until now?
No.
What have we not received, ma'am, to your knowledge?
We have not received from July of this year through the 30 days prior to the trial. So July through October, no additional supplements were submitted at all.
Are you aware of any requests made for those documents?
Yes.
Are you aware of any responses?
Yes.
To our request?
Oh, no. No.
Do you know whether Mr. Hodges agreed to produce these statements or not, ma'am?
I don't know.
But what you do know is that we don't have them. Is that right?
Right. That's what I know, is that we do not have them.
And so we don't have any bank statements from July 2021 up until the current, do we?
No.
Why do you believe we do not have those statements?
Objection, cause for speculation.
Sustained.
Do you know why we don't have those statements, ma'am?
Mr. Hodges is hiding income and expenditures.
Objection, Judge, speculation.
Sustained.
Ms. Hodges, you prepared a summary of spending for the court, which has been previously offered and admitted as Petitioner's Exhibit number 23.
Yes.
I'm going to reference you to that.
Okay, let me get to 23. Hold on. Okay.
And it starts with January 1st, 2020 until January 31st, 2020. Is that correct?
Yes, the first page.
Can you tell the court how you came up with these amounts and expenditures listed on the left of each column?
I reviewed each bank statement and added up the totals for each of the different categories that I have listed there.
And so going through your statements, let's go on to page 2 because I have petitioner's exhibit number 5 up as well. And Judge, do I have permission to share screen so I can do a side-by-side for the court?
You do.
Thank you, Your Honor.
So are we still on the first page or the second page?
I'm pulling up Mr. Hodges' bank record right now
Okay.
so I can do a side-by-side for the judge, but I've got too many exhibits pulled up. I need to start eliminating some of them so I can pull it up. I apologize, Judge, for the delay. I've got all these exhibits pulled up and it's eliminating what I can pull up at this time. So I'm trying to X out some of them. So let me go back to, all right, I'm going to share my screen at this time. Okay, Ms. Hodges, are you able to see my screen?